Fresh admission item number 1.
Pardon to mention, my lord, I mean VC, my lord.
My lord, second writ petition, Honorable Single Judge shall second writ petition is not pending. That was decided by this Honorable Coordinate
That
Bench.
you can challenge before the Supreme Court. The only thing you have pointed out that there is a typographical error. That can be corrected, not otherwise.
Typical errors, my lord. All the errors. Typical error, page
It is 12/9/2023.
12/9, that will be 9/6/2021.
9/6/2021. The present review application. The present application has been filed seeking review of an order dated 15/2/2024, passed in WA number 92 of 2024. So stop. By the said order, this court had declined to interfere with an order passed by the learned single judge, whereby the writ petition was dismissed on the ground that second writ petition was not maintainable. So stop. Student counsel appearing on behalf of the petitioner has attempted to convince this court that in the given facts and circumstances, the second writ application was maintainable. So stop. We are not inclined.
Judgment of this Honorable Court in a single bench.
Huh?
Judgment of this Honorable Court, my lord. That
Yes.
has slipped. That's not taken notice of.
In the light of division bench decision of this court, which could not be taken note of. Division. So stop.
Single bench. my
Hello,
lord.
single bench.
Single bench decision.
Single bench.
Single bench decision.
Not taken. Stop. We are not inclined to entertain the present review application on the ground taken by the petitioner. So stop. Learned counsel for the petitioner has, however, rightly pointed out that there is a typographical error in the order dated 15/2/2024, wherein comma in paragraph 4, 12/9/2023 has been typed in place of
9/6/2021.
9/6/2021. So stop. Yes, Mr.
We have no objection.
The said order dated 15/10 to the 15/10/2024,
15/2.
15/2/2024 is lit in paragraph 4 of the order dated 15/2/2024, passed in WA number 92 of 2024, comma, what is the date? 20? What is the correct date?
9/6/2021.
9/6/2021 be read in place of 12/9/2023. So the court's order dated 15/2/2024, passed in WA number 92 of 2024, shall be read along with the present order.
One, my lord. On 9/6/20, for contempt, there will limitation, my lord. I will remit less. Permit to file a contempt.
This application stands disposed of accordingly.
I may pardon to make a mention. Read appeal for fresh admission. Read appeal for fresh admission.
Then I'll please give your slips. We will consider one. And if there is any urgency, then please point out in your slip that this is the urgency.
Execution case, because of execution case has been proceeded, that is fine.
You give your slips, we'll see.
Please write the reason in your memo so that that can be considered.
You can mention the fresh admission after notice and then the urgency. All right. So all the matters shall not be listed. Only such matters where the court finds that there is some urgency. At times, we may call for the records also to appreciate the urgency. But at least it should be clear in your slip that this is why the matter is urgent.
My lord, may I have your lordship's indulgence, my lord, to point out this mention memo, my lord. This is a matter, my lord, which arises, your lordship will recollect, my lord, that arbitration matter for reference under 29A for increase of time.
Right.
Lordship has delivered the judgment, my lord.
No, we delivered the judgment, but before we could sign that judgment,
My lord,
we noticed the Supreme Court.
I am obliged, my lord. So I am only seeking listing, my lord.
List that will be
My
listed.
lord, my only prayer, my lord,
That will be listed.
my anxiety, my lord, is, my lord, the International Court of Arbitration has informed me that the draft award is ready. Hence, my lord, it's
All right.
incumbent upon me to approach
right.
the
All right.
learned court below to get
All
the
right,
extension of time.
all
So
right.
kindly, my lord, consider.
All right.
My lord, deeply obliged. Any day this week, my lord,
It will
subject to
be
your
listed.
lordship's convenience. Deeply obliged.
One matter from the list, item 59, that's a tender matter, as well as there's a PIL which is filed that tender matter. And there's a stay operating against us and it's a public work, so you're not.
Have you filed any application for vacating the order of stay?
OCAC has filed. One of the main government opposite party has filed.
Who are you?
I am one of the private opposite.
So
party.
you should have filed an application, then make a mention.
Yeah, see, the whole thing is that the tender results are not out, so that makes our situation very precarious.
Lordship, may I
Neither here,
beg
neither
to
there.
intervene, my lordship, may I beg to
Petition is against
intervene?
This
I
mention
was-
is made by the state, not by you.
My lordship,
Okay.
may I beg to intervene, my lord? This is the same matter in which I was going to mention, my lord. I
Yes.
have filed a vacation of stay petition
Yes.
in the same case, and this is the tender matter which is coming along with the PIL being the main matter. My lord, the writ petition has a stay which has been operating for more than almost 5 to 6 months.
All right, we will see.
We
We will try to take up.
Yeah, it on 7th at 2 PM, I think if your lordships will accommodate us 7th at 2 PM.
No, we don't know whether it can be taken up today also. Why?
Look, we'll wait.
We'll try.
If it doesn't, we'll again remind your lordships at 8 of the.
May pardon mention a
Pardon to
permitted
mention,
mention.
my
Item
lord.
48. Lordship has granted four adjournments. This state has been taken time to file counter affidavit. Till date, not in file. And last time they undertake to file. It relates to a blacklisting matter. My lord. So, Lordship
So we'll decide the matter based on your pleadings. Will not wait further for the state to file.
Grant some time, with time.
No.
My-
This is not the way.
My-
If you have to, you can
Okay.
still file. Blacklisting is a serious matter.
Your lordship, I may be pardoned to mention item 57, your lordship. It is a tender matter, your lordship. Over there, in that case, we have filed an additional affidavit which has not come on record, but it's a tender matter and there is some kind of urgency in that matter, your lordship. If your lordship
So
kindly-
let the additional affidavit come on record first.
If your lordship kindly directs the registry to.
It will come. No written order is required by the village. Oral is enough. I have asked.
Pardon to mention, my lord, in BC, my lord, permitted to my lord. One review petition 181/2022. Due to some
Send your slip.
information.
Send your
the
slip.
applicant-
Please send your
my
slip.
lord.
Who are you? We can't see
No,
you.
no.
Your video is not working. You have not given whether you are an advocate or a party.
Send your slip.
Item number 1.
This is that lease cancellation matter.
Yes.
The time shortage, because it could not precipitate. I could meet the managing director only in the evening of Friday, the residence. So nothing. So what I was praying, subject to your lordship, may give me some 10 more days time so that we can talk out. There is some chance, as I have heard.
You are happy.
All right with me. Only difficulty is that we had sent a mail. First went to your
No,
lordship's order.
that mail, I forgot to mention, tell him, that mail which they have sent, that mail is no more existing. So therefore, I was told by my client. So I will give the mail ID. There's no mail ID is given. My client will go and meet them. So your lordship may give some considerable time, 10 days time or something like that.
Let us resolve. Please resolve it.
I think there's some chance.
Call them for.
That is good. As requested by, on behalf of the petitioner, requested by senior counsel and senior counsel appearing on behalf of the petitioner, list this matter on so and so on 2 weeks.
2 weeks.
2 weeks as the first case. So from, he has informed this court that there is some chance of amicable resolution of the dispute.
Okay. Interim order to continue.
Interim orders, I'll continue in the.
Item number 2.
Yes.
This is the case, my lord. Last occasion, my understanding, they said that there is some judgments contrary to the law laid down by my lords in that case of State of Odisha versus Joseph Barry. So that matter relating to during pendence of criminal case, whether one will get promotion. Before my learned friend starts, may I submit the notifications and the judgments?
No, his contention is that if a view was to be taken different from the view in the other, by the other coordinate bench, the matter could have been referred to a larger bench.
Yes.
This is what he was submitting.
Yes.
That's all.
That my submission before my lords, that in that earlier 2 judgments, no direction was given to grant promotion during pendence of a criminal case. On the other hand, in those 2 cases, the ratio was decided during pendence of the criminal case, one is not entitled for promotion. So there is no divergent view in those 2 cases which has been relied upon.
So what are those decisions?
That decision, Anil Kumar Sethi, and I have given that documents also, that State versus Somnath Sahu and State versus Anil Kumar Sethi. And these 2 judgments has been taken into account in the case of Joseph Kumar Bari. And one aspect I will clarify, that in that Somnath Sahu case, one aspect was there for directing to give him ad hoc promotion. In the present case, that direction cannot be given because that ad hoc concept of ad hoc promotion was granted by virtue of a notification which has been subsequently withdrawn. And your lordship has already decided the same issue, your lordship, that this point was also raised, and your lordship has already decided the issue in the case of, I have given that copy of my lords that.
Where have you given?
Before the court master last occasion. That in that Devi Prasad Nanda case, WA number 16 of 2024. WA 16 of 2024. Right.
Anil Kumar Sethi and the other one you given. Those 2 you had.
No. I am presenting that my lord's judgment at Devi Prasad State.
Okay, sorry. Latest.
Do you have a copy?
Yes, ma'am. One copy I am giving. Your lordship may see para 8 of that my lord's order. Para 8.
Yes. That's all.
Yes, ma'am. If a lordship will wants that, I can give that circulars that regulating the promotion during pendency of criminal case and departmental proceeding, that will clarify, my lord. I have given it.
Yeah.
Just I'll show my lords the three circulars. Your lords may see the first circular. After Janaki Raman case, state government issued a circular on 18/2/1994. That is page 1.
Page?
One of my sorry, my lord, that has been.
Page 1.
Yes, ma'am. That you also may see that the notary office memorandum dated 18th February 1994.
Yes.
There you also may see para 4.
Yes.
That for the first time this seal cover procedure was adopted, and by virtue of this office memorandum, that is after Janaki Raman case, my lord.
Yes.
Again, I love drop my lord's notice to page 3, my lord. The subsequent notification of the next DPC to be held in normal course to decide whether the employee is suitable for promotion on ad hoc basis. If the employee is considered suitable on the basis of totality of his records without taking into account so and so, these are the conditions. On these conditions, if one fulfills, then he'll be considered for ad hoc promotion.
Yes.
There are subsequent notification. I don't want to bring my lord's notice to all those notifications. Your lord's may then turn to page 9. This is a notification dated 29th April 2017.
Yes.
There, the notification which was allowed ad hoc promotion, that was withdrawn. You may see para 3. Government, after careful consideration of the above aspect, have been free to withdraw this department office memorandum dated 14640 dated 4/7/1995 with the direction that henceforth all the so and so on. That notification giving ad hoc promotion, that was withdrawn. And the subsequent notification is the last notification, 17th June 2021.
Yes.
There it has been decided that if during pendency of departmental proceedings, so far as criminal case is concerned, there was no consideration. So far as departmental proceeding is concerned, if it is held up more than 2 years, then that for ad hoc promotion will be considered subject to fulfilling all these conditions. And I have relied upon judgments, my lord, that subsequent that.
Where is that?
That you also may see, you also got it page 11. That is the notification.
11 is there at page 12.
Page 11, para 2.
Page 11, para. Yes.
After careful consideration of the above aspect, it has been decided by the government to prescribe the following principles for consideration of ad hoc promotion of government against whom disciplinary proceedings are pending for more than 2 years.
Yes.
Then, my lord, if these are the conditions.
Yes.
Page 11, para 2 of what?
My lord,
No.
Okay.
that's compilation. That I have given that compilation. My
He has given.
Another one is given.
no, my lord, my problem is that this has been. All these notifications have been taken into account by the Honorable Division Bench earlier in that Joseph Barry case. And in Joseph Barry case, I have annexed that judgment in my writ appeal. Your Lordship can get it from page 24, annexure 3 of my writ appeal. At para 8, my lord. 8 page 35,
Appeal.
writ appeal,
Page.
page 35, my lord, para 8 of that judgment, that Joseph Barrick case. The court has been shown a compilation of office memorandum and of notifications issued by the government of Odisha from time to time. These include office memorandum dated 18th February 1994, 4 July 1995. All these notifications which I have shown to my lords just now. And further in, sorry,
Yes.
paragraph 9. Further in terms of the law explained by the Supreme Court.
Just a minute.
Sorry.
Yes.
Then para 9, madam. Further, in terms of the law explained by the Supreme Court in the Union of India versus KB Janki Raman, 1991 4 SEC 109, State of Punjab versus Chamalal Goel, 1995 2 SEC 570. The judgment of this court dated 5th October 2016 in WPC number so and so, State of Odisha versus Somnath Sahu, and the judgment dated 26th April 2000 in WPC number so and so, State of Odisha, Anil Kumar said there is no right of the government servant to be considered for promotion during pendency of either departmental proceeding or both against such government servant.
Yeah.
And ultimately, your lordship directed para 12.
Yes.
In the light of the above orders of the government, it is not possible for this court to sustain the impugned order of the land signature in the present case, directing the appellant to grant regular promotion to the respondent, even with the caveat that such promotion would be subject to the outcome of the criminal case against the governments, the shape of the so and so. Your lordship decided during pendency of the criminal case, one will not get promotion. That is the ratio. And relying that judgment, your lordship also passed that I have given that WS 16. And there is no divergent view that one will get promotion during pendency of this.
Yes, so the only point for consideration is as to whether there is any divergent.
Yes,
according to him, the views are divergent. According to you, there is no divergent.
There is no divergent view.
So we will hear.
May I please, your lords? My learned friend read my lord Joseph Barrick case in para 8 that the 4th of July 1995 notification does not speak about ad hoc promotion.
No, that is not the question.
My,
The question before us is whether we should follow Joseph Barry's decision or not.
my lord, lordship right.
According to you, the view taken in Joseph Barry is divergent from view
My lord.
taken in some other case.
My lord.
So which is the other case in which a divergent view has been taken?
In Joseph Barrick, 3 judgments referred by the Honorable Division Bench of this Honorable. First, KV Janekrama. Your lordship kindly see in my note, I have.
KV Janekraman is Supreme Court,
My lord.
not the High Court.
My lord.
So show us any decision of the High Court of Ordinate Bench
My lord.
which has taken a
My lord.
different view
Before.
than taken in Joseph Barry.
My lord,
That is the
before-
only question.
My lord, before going to the High Court, Honorable High Court judgment, division bench, your lordship kindly took one paragraph of the KP Janakiraman case. One paragraph. I have given my note. Your lordship kindly see at page that is in my note, para 16, my lord.
No, but now today you are changing.
No, I am not changing. I will go to. In KP Janakiraman's case, Honorable 3 judges of the Appeals Court has held that if a charge memo in the disciplinary proceeding and charge sheet in a criminal case is filed against the delinquent employee, then he should not get any promotion. First thing. In the instant case, the DPC was held and promotion, first DPC was held and promotion was given. No disciplinary proceeding was initiated against the present petitioner. Only criminal case was initiated. No charge sheet by the, still under investigation. My humble submission is, so far as criminal case was initiated in 2016-17, still is under investigation by the police, no charge sheet framed, and the date on which DPC was held and promotion was given, no disciplinary proceeding was initiated against the petition, against the respondent. Therefore, the Honorable Division Bench of this Honorable Court, relying the KV Janakiraman that no promotion should be granted even if pendency of criminal case. Two things, pendency of a criminal case and filing of the charge sheet is different things. Mere pendency for long years is different thing. Therefore, three judges bench of the Honorable Supreme Court has clearly clarified that the moment in a disciplinary proceeding the charge sheet is filed and in a criminal case charge sheet is filed, it is said to be that criminal case is pending or disciplinary proceeding is pending against the employee concerned. In the instant case, when the junior was promoted, no proceeding was initiated, departmental proceeding was initiated against the petitioner. That is, proceeding, my DPC was held on 9/11/21, promotion was given 11/11/21.
DPC was held on
9/11/21.
9/11/21.
Promotion was given on 11/11/21.
Promotion was given to whom?
Juniors.
And criminal case was filed when?
My departmental proceeding was initiated on 19/4/22.
Forget, criminal case was instituted when?
Criminal case was in 2016.
Yes.
And departmental proceeding was initiated on 19/4/22. 19/4/2022.
Yes.
Therefore, my humble submission is, so far a Ramadan case is concerned, I am directly covered in that case because no charge sheet in the criminal case was filed even though pending and no departmental proceeding was initiated against the petition. This is the first question. My learned friend deliberately did not, with due respect, did not place that fact.
Please don't.
Well, sorry, I'm sorry. Second thing, my lord, is concerned diversion of view. Your lordship kindly see Somnath Sahu case. Somnath Sahu case, after interpreting the various circular of the government and decision of this division bench held that, this honorable court held that 4795 circular for ad hoc promotion to strictly act, the very word was mentioned, to strictly act for ad hoc promotion in accordance with the 4795 circular. That was, my lord, 4795 circular is for ad hoc promotion even if.
But that was withdrawn subsequently.
My lord.
That was withdrawn subsequently, that notification.
But 4795 circular is concerned. But judgment was there, my lord, to act, my lord.
Judgment was there, but 4795 circulars were withdrawn subsequently.
They have not, for the first time they are saying that was withdrawn, but they have not mentioned the writ appeal that a circular was withdrawn. Had they mentioned, in this regard, I would have this, my lord. Course, my humble submission is that the force particular 7, whether withdrawn or not, I will to verify, my lord. Therefore, once the Somnath Sahu case was decided to act in accordance with 4795 circular.
What is Somnath Sahu?
Somnath Sahu case, my lord, note you.
Just give the citation.
My lord, that is page 34. Page 34 to my citation, my lord. 2016 SCC. 2016 SCC, Orissa 692.
SCC online.
Online, Orissa 692.
Yes.
So for Anil Kumar case is concerned, the division bench of this honorable court relied. In that case, in criminal case, charge sheet was filed. Court taken cognizance.
Right, we understand that distinction. That in your case, the charge sheet has not been filed. And in the other cases, charge sheets were filed.
Mine.
So in your case, according to you, since charge sheet has not been filed, criminal case is not pending. And in view of Janki Raman. So your submission should have been different. Your submission should have been that in case where the charge sheet has not been submitted in the criminal case, it will be governed by the decision rendered in case of Janki Raman. All right. So no circular, nothing shall supersede that decision. This should have been.
This is the law of the land.
Let us see what is Janki Raman.
Janki Raman, in my notes, in note sheet, your lordship kindly see. That is, my note sheet at starting page 13. Page 13 at para 16. Relevant page 22, my lord. Relevant page 22. May I read page para 16, my lord?
Yes.
On the first question as to when, for the purpose of the sealed cover procedure, the disciplinary criminal proceeding can be said to have been commenced, the full bench of the tribunal has held that it is only when a charge memo in a disciplinary proceeding or a charge sheet in a criminal prosecution is issued to the employee that it can be said that the departmental proceeding criminal prosecution is initiated against the employee. The sealed cover procedure is to be resorted only after the charge memo charge sheet is issued. The pendency of preliminary investigation prior to the stage will not be sufficient to enable the authority to adopt sealed cover procedure. We are in agreement with the tribunal on this point. For your lordship, kindly see next para, page 23, para 17.
Yes.
Next para 17, my lord.
Yes.
There is no doubt that there is a seeming contradiction between the two conclusions, but read harmoniously, that is what the full bench has intended. The two conclusions can be reconciled with each other. The conclusion number 1 should be read to mean that promotion, etc., can be withheld merely because some disciplinary criminal proceedings are pending against the employee. To deny the said benefits, they must be at the relevant time pending at stage when charge memo charge sheet has already been issued to the employee. Thus, read, there is no inconsistency in the two conclusions. Your lordship, kindly see another para, relevant, para 32, my lord, page 28. Para,
Yes.
para 32. In this case, no charge sheet was served of the respondent employee.
No, that is regarding the departmental proceeding.
My lord,
So-
DPC was to consider respondent promotion, yet the sealed cover was adopted. The tribunal has rightly directed the authority to open the sealed cover, and if the respondent was found fit for promotion by DPC, to give him
No,
promotion.
32 is not relevant. That is regarding disciplinary proceeding.
My lord, disciplinary proceeding was not initiated.
All right.
My lord.
Disciplinary proceeding was not.
And para 35 also in the same line,
Yes.
with for giving consequential regular promotion with consequential benefit.
Yeah.
As directed by the Honorable Single Judge of this account, which has been impugned by the state government.
Yeah.
Your lordship, kindly see Somanath Sahu case at page 34.
Yes.
Relevant para, my lord. Para 9, page 37. May I read, my lord? Before closing the matter, we think it appropriate to bring certain things to the notice of the petitioner. Though the government in GA department has issued circular letter 4795 for reviewing the withheld promotion cases after expiry of 2 years from the date of first DPC. However, we often find that such review is not undertaken within a reasonable time after expiry of 2 years from the date of first meeting of DPC. This ultimately results in defeating the spirit of the GA department circular letter 4795, which has brought into eliminate the grievance of the government servant against whom criminal proceeding, public disciplinary proceeding have been pending for long. Therefore, the appropriate authorities
So
should
why
be
are you,
directed.
Mr. Counsel, why are you relying on Somnath Sahu? Somnath
No.
Sahu is not supporting you.
My lord, I'm not.
Janki Raman supports you.
Danar government supports me.
So why?
What I humbly submit, even if Somnath Sahu case directed for Adaka promotion,
Somnath Sahu is different. Somnath Sahu, in Somnath Sahu, that circular has been taken note of
Right.
4/7/1995.
And in
Not
university
the
case, my lord, charge
subsequent
memo, in criminal case, charge sheet and cognizance taken. Therefore, that is the difference.
All right. Yes.
Right.
Yes, what is your response?
Your Lordship may say three, I will show my lords 3 dates. And your Lordship has seen that Janakiraman case, as per the para 16, if as on the date of DPC, either in the departmental proceeding or criminal case, charge sheet is not submitted, then seal cover procedures shall not be adopted. This is the law. Your Lordship may see the writ petition filed by petitioner. Page 13 of the writ petition, my lord. Writ petition, my lord. Your Lordship got it? Writ
Just
petition.
And also read,
just allow him to speak.
my lord.
Yes.
Your Lordship may see page 13 of that writ petition. Your Lordship may note down that date 19/4/2022.
Yes.
That departmental proceeding was initiated. He has admitted it in paragraph 6 of the writ petition. Your Lordship may see paragraph 6 of the writ petition. Page 5 of the writ petition, paragraph 6.
Yes.
Then Your Lordship, there he has admitted the proceeding was initiated on 19/4/2022. Then Your Lordship is paragraph 7. Promotion was given on 6/6/2022.
No, it's not the question.
I am coming, my lord. Your Lordship, I am drawing my lords 3 dates. Departmental proceeding 19/4/2022. Promotion was given on 6/6/2022. Then Your Lordship might see the
2002 promotion was given to whom?
he is saying that junior.
Oh, but it says that the DPC was held on 9/11/2021.
I am drawing my lord's notice.
That is subsequent DPC.
Please.
Sorry, man, sorry.
He has admitted that junior was promoted on 6/6/2022. Your Lordship may see that promotion order. Page 21, annexure 2. The first line, having been selected by the Central Selection Board held on 27/5/2022. But I'm 3 dates, my lord.
Yes.
19/4/2022, the admitted fact departmental proceeding was initiated.
Yes.
It is also admitted fact that the CS, that is in police department, that is Central Selection Board in place of DPC. That is CSB held on 27/5/2022. By that date, the charge sheet in the departmental proceeding has been submitted. And the promotion has been given on 6/6/2022.
Yes.
So how can he get the benefit of Janakiraman case?
Yes.
And Your Lordship, I am reading his affirmance made in the writ petition. In the writ petition, paragraph 7, he has said, may I read, my lord? That gradation list of police as one was published as per the AIG police personnel letter number 7/8/2021. In the said gradation of the list, the name of the petitioner finds place at serial number 137. One Chandrasekhar Jana, whose name finds place at serial number 365 in the said and sufficiently junior to the prince, was given promotion totally ignoring the who was senior. It is pertinent that Chandrasekhar Jana, while containing a voice in Paris so and so, so and so, but he was given promotion, on 6/6/2022. This is his appointment.
So there is no dispute that the DPC was
Yes.
held on 27/5/2022.
There is no dispute. And he is relying that promotion order.
So did he state in his writ petition that
That-
DPC was just a minute, that the DPC was held on 9/11/2020?
No such affirmation in the writ petition.
Para 9. Your Lordship, kindly may I place my para 9.
In peculiar facts of the present case, we will give you an opportunity to respond. Yes. Yes, Mr. Patel.
Yes, that's
all.
3 dates.
That's all. That's all.
My lord.
Para 9 of the writ petition, Your Lordship, kindly see. Before the Honorable Single Judge.
Para 9 of?
Writ petition of the Honorable Single, before Honorable Single Judge. Writ petition.
Yes, writ petition was there before Honorable Single Judge.
It reveals from the letter dated 12/5/21 by the Annexer 4, issued by IG of Police Personnel Odisha, State Police Headquarters, Cuttack, that the names of the eligible sub-inspector of police who have completed 6-year service as on 1/1/21 after passing SI course of training were forwarded for special CSB for promotion of SI police to.
Mr. Counsel, please tell us
Mine,
or please satisfy us
mine.
on a fact that the DPC was held on 9/11/2020.
That is para 9. That is para 9 in pursuance to 12/5/21 letter. DPC was held on 9/11/21. Your Lordship, I am producing that document, page 80 to the my written notes, mine. That
We will not see your written
9.
notes.
In this I have mentioned, my lord.
Please, where is that?
Your Lordship, your Lordship may read the entire para, mine.
Yes, yes.
It reveals from the letter dated 12/5/21 by the Annexer 4, issued by the IG of Police Odisha, State Police Headquarters, Cuttack, that the name of eligible sub-inspector of police who have completed 6 years service as on 1/1/22 after passing SI course of training were forwarded for special CSB for promotion of SI of police to the rank of Inspector of Police for the year 2021. In the said list, the name of the petition finds place serial number 128, the name upon Borsa Mahathi finds place serial number 130. Junior to the petition and said Borsa Mahathi got promoted to the post of Inspector of Police, totally ignoring the legitimate claim of the Borsa Mahathi got promotion on 11/11/21 as per DPC on 9/11/21.
Where are you reading?
Borsa Mahathi, I am stated, my lord.
9/11/2021 mentioned.
Borsa Mahathi got promotion.
Sir, you made a submission that the DPC was held on 9/11/2021. Where is that pleading in the?
I pleaded, my lord, on the basis of 12/5/21, Borsa Mahathi got promotion. That DPC was held on, even though exact date of DPC was not mentioned. Your Lordship, kindly see page 8 of the DPC date was mentioned. Page 8 of my written note, I have given that date was mentioned on, and Borsa Mahathi junior to the
For
petition.
written note, we cannot go by your written notes of submission.
My lord. Borsa Mahathi I have mentioned, my
And single judge has decided your matter based on your pleading.
lord.
All right.
And Borsa Mahathi, the promotion order, my lord, is 11/11/21. That is page 8, mine. And in that 11/11/21, page 8, the DPC date was mentioned 9/11/21. Borsa Mahathi name is finds place at serial number.
You are reading paragraph
9 of the
paragraph 9.
of the writ petition, that Borsa Mahathi junior to the petition got promotion.
Where is his promotion?
Promotion order, your Lordship, kindly see. Even though I have not annexed at the relevant time, not got, I have a page 80, my lord.
It's impossible. You can seek review. Unnecessarily, you are wasting time. If you are, according to you, certain facts which were important for the learned single judge to decide, which were not brought to.
But my pleading, they have not,
File a
with
review.
due respect, well, they have not disputed.
Huh?
They have not disputed this fact. They have not disputed this fact before the honorable single judge.
For applying Janki Raman, that is the problem. That you did not, you are taking this plea now. This plea you had not taken earlier.
But my pleading, due respect, my lord.
As you can prove your pleading before the learned single judge, not before the division bench. As you wish. If we have to decide, we will be deciding it. We'll be laying down. Wish.
My lord.
As you wish. If you want us to decide, we will be deciding.
Or your lordship remand the matter on that issue.
We will not remand. We will decide.
Because they have taken the point that in the writ appeal, they have taken the point that at the stage of admission without hearing their main point. At the stage of admission without hearing, they have decided, the honorable single judge decided.
See, their contention is that according to you, you have relied on certain promotion orders by which your juniors were granted promotion. Those promotion orders indicate that the DPC was held much after the charge was served upon in the disciplinary proceeding. According to you, the DPC was held on 9/11/2011.
My lord.
We do not find any material, any specific government in your writ petition to this extent.
My lord, on the basis of Annexure 4, I have given Annexure 4 and also pleading that Borsa Manthi was promoted, and Borsa Manthi promotion order reveals that DPC was held on 9/11/21, my lord. With due respect, I am saying. The pleading they have not disputed. Neither in the writ appeal,
You should have, if you are relying on Janki Raman, you could have developed your pleadings accordingly.
Right.
Not now. All right, start. Counsel for the appellant. Yes.
Item number 3.
this is that matter, my lord, based the claim of regularization of outsourcing employee. You lordship wanted me, my lord, to see before the Supreme Court judge. Well, I have got all the, first of all, I have indicated to lordship, my lord, the honorable single judge of this honorable court allowed regularization of outsourcing employee. That was also confirmed by the previous division bench. And matter has been carried to Supreme Court. Supreme Court, my lord, is in the session of the matter.
No, certain matters are pending for judgment.
No, judgments have been delivered.
Judgment have been delivered.
Yes, and it has been challenged before the Supreme Court. I have got, my lord, all the orders, including, my lord, the honorable single judge relied upon judgment of the 3 Supreme Court judgments. Based on that, my lord, because they have taken the plea, there is no master-servant relationship in this.
There is a decision of this court.
Well,
Division bench decision of this court.
well,
You are bound by that.
no, it's so to I have brought that order. But my difficulty at this moment, my lord, I have indicated to lordships on last occasion. In the meantime, my lord, they have terminated my service.
No, no.
So, my lord, I have to take alternate remedy challenging the termination.
Where? Where will you go?
Before the honorable single judge,
Who has terminated?
the respondent number 3, my lord.
Who is responsible?
The Deputy Director of the Government of India dispensed
You are saying you have been your service were taken based on outsourcing.
that is the exactly my issue. My lord, kindly have a glance to this order. After, my lord, the judgment.
What do you want now?
Well, first of all, my lord, if you also look at this order, this was passed by, if at all I was allowed to continue as the outsourcing employee, my lord, they could not have terminated my service. And They have terminated my lord because the honorable single judge dismissed the writ application. My lord, kindly see the order. And so far as this petitioner is concerned, my lord, the honorable single judge, my lord, I have shown to your lordship from the last occasion.
This is Government of India.
Yes, my lord.
Yes, yes. It is CGHS is a Government of India organization who giving the medical service for the employees, and these are the contractual nurses, those who are serving there. Then honorable single judge confirm that they are not in the approved post is there, they are contractually engaged. Accordingly, it was dismissed.
My lord, kindly come to page 82, my lord. There is a factual error. Only I was selected. The honorable single judge said, though the petitioner was selected through a regular recruitment process conducted by another government of India agency, my lord, who was given the authority to cause its recruitment, my lord. They said, in absence of vacancy, one man was selected and the other man was, so far the petitioner is concerned, he was appointed on outsourcing basis. That's a factual error, my lord. If you also look at page 42. Page 42, my lord.
No, where is your initial appointment letter?
Initial appointment letter, my lord, annexure 3, the selection letter. Selection letter, my lord. Annexure 3, page 40.
Writ petition is not there.
Page 42, madam.
Writ petition is not there.
No, she was earlier appointed on the government of Orissa, my lord. She resigned because being selected here, my lord, for government of India dispensary. Yes, yes. There, but continued, my lord. The unwillingness was shown, but he continued. No, I have given that letter, my lord, unwillingness. Yes. My lord. Kindly come to page 42, my lord. The factual error is this. Page 42, my lord. I was the only candidate selected. Page 42 of the writ appeal, my lord.
Writ appeal?
Yes, my lord. My selection, my lord. Pursuant to the advertisement in annexure 2, page 40, my lord. Interview board, my lord, conducted by 3 officials of Government of India organization.
Mr. Where is your engagement?
Well, I'm sorry, well, engagement order was not filed, my lord, along with the writ application. The extension was filed.
Sorry. All right. Where is the extension?
Well, that extension order, my lord. Page, my lord, annexure 10.
Page,
my lord, 60. There, my lord, in para 2. My continuance has been indicated. From 16/6/2005.
where?
Para 2, my lord, page 60, annexure 10, para 2, my lord. And there, my lord, since we have completed 10 years, recommendation was made to the director to regularize us. That was not acceded to, my lord.
The recommendation of the additional director.
Yes, ma'am.
Appointment order.
Appointment orders, madam, unfortunately, madam, that was not filed in the writ petition.
The basic idea is
Yes,
that only that agency will regularize your services if it can regularize, which had engaged you.
correct, madam. No,
Right. So that is the
but that,
crux of the matter.
madam, there's a different angle, madam. Different angle based on 3 Supreme Court decisions, whether there still exists a master-servant relationship and who is the real employer. Following that, madam, the Honorable Single Judge, two Honorable Single.
Those decisions
Madam.
of the Supreme Court relate to regularization of services.
No, your lordship is correct in that. It was not a case of regularization, but here, madam,
Must
case
be a case under the Employees Provident Fund.
under labor law as well as madam in doctor's case also. One judgment 2021 7 SCC madam 155 that relates to a case of doctor. On the same principle, whether there still exists a master-servant relationship, so as to give the benefit of the insurance policy, madam.
Exactly.
Madam, I'm not denying that.
Exactly.
I don't-
Those that is different. That is and therefore for
Madam,
last occasion also I had
I'll just show to your lordship madam, one judgment of the Telangana High Court, madam. The only question whether outsourcing employee can be regularized, and based on the Supreme Court judgment, madam, in
the
Dharangadhar.
High Court's judgment will not bind.
No, I know, I'm not saying that. I just
And since we have already decided
well,
that you cannot be given regularization. Is there any judgment reserved?
well,
By-
I have no.
Huh?
No, I have no idea, madam. Whether your
No,
lordships
you
are.
were appearing in many of the cases.
But the batch of cases were listed, madam, because this case is taken up. So I thought, I think, madam, I will persuade your lordship madam, to accept the Honorable Single Bench order, or else, madam, to wait until the matter is taken up by the Supreme Court.
No.
No, the same issue, madam, the same issue on the Honorable Single Judge order, confirmed by the division bench. Then, madam, in 4 matters, 2 were dismissed on the ground of limitation, and 1 was 2 hours on merit also,
All right.
condoning the delay. And here, madam, kindly come to page 42 for a minute.
Yeah.
Page 42.
Yes, just show the decision. This is why every time we cannot adjourn the matter.
No, page 42, madam.
Just show the decisions.
Also,
yes.
just before that, now, page 42. Page 40.
Page 42.
Page 42, madam, selection, madam. Page 42 of the writ application.
Selection is immaterial. Your employment is material.
No, but the Honorable Single Judge said,
Mr. Counsel, on the last occasion also we had heard you,
madam,
and you had informed us that there are Supreme Court's decision on this point,
Madam.
and for that purpose only the matter was adjourned.
Madam.
So as the decisions
Madam,
conclude the
madam.
hearing.
also,
Conclude your submissions.
madam. Madam, first judgment was delivered by the tribunal.
Mr. Counsel, if you have any decision of Supreme Court, please refer to that.
Madam.
Don't refer to the tribunal's judgment for this court to consider.
No, madam, that was upheld by the Honorable Court and the Supreme Court.
All right.
Madam,
So show us the Supreme Court's decision.
Supreme Court decision, madam, if you also look at page 44, madam.
Yes, page 44.
Yes, madam. The judgment is, madam, 57 Supreme Court, madam, 264 Dharangadhar Chemical Works versus State of Saurashtra.
All right, that is different. That is industrial dispute.
And madam, the second judgment is
Yes.
Hussain Bhai Hussain Bhai versus Alat Factory. Alat Factory. This is my lord, 878 Supreme Court 1410.
This is
This is my lord on master servant relationship.
master servant.
Yes, madam. Page 60, para 5.
Yes.
And another judgment, my lord, State of UP versus Od Narayan Singh.
Yes.
That is my lord, 65 Supreme Court 360.
Yes.
That is following my lord the earlier judgment. And our the single bench judgment, my lord, is page 62.
Yes.
Rudrakanta Panda versus State of Orissa. There are 5 cases.
Yes.
And the date of decision, my lord, 19/1/2022. I'll refer to my lord paragraph.
Yes.
This was outsourcing, my lord. Paragraph 20. And 26, my lord.
Yes.
And finally, in para 31, the writ petition was allowed. That is, my lord, page 81.
Yes.
Then, my lord, can you come to page 83, the writ appeal?
Yes.
3 writ appeals orders, my lord, have enclosed.
Yes.
First is 83, my lord, State of Orissa versus Pramod Kumar Mallik. Out of those 5 cases, 1. This was, my lord, after condoning the delay.
Yes.
Without condoning delay, my lord, that was dismissed. Then page 85, WA 562 of 2023.
Yes.
State of Orissa versus Sushil Kumar Mahanti.
Yes.
That was also dismissed for default. But dismissed on the ground of delay.
Yes.
Then the third case, my lord.
So these are Supreme Court's decisions.
No, my lord, the
Don't waste court's time.
but the third judgment, my lord, can you see? The third judgment was on merits, my lord. And I have given, my lord, the another judgment of the Honorable Single Judge, Sujit Das, WPC number 20944 of 2023, decided on 14/7/2023. And, my lord, that was also allowed, my lord, by the Honorable Division Bench. In writ appeal number 2366 of 2023. And, my lord, so far as this first judgment of the Honorable Single Judge is concerned, my lord, kindly come to page 89. The Supreme Court directed the government of Orissa to indicate by way of affidavit how many outsourcings are there, how many direct contractuals are there. And they have taken time, my lord, and on the last occasion, on 12/7/2024, my lord, notice was issued, and that judgment of the Supreme Court was stayed.
Dismissed.
Well, only one liberty, my lord, to challenge that termination. Because that termination was
No,
based.
no, we will decide on merits. There is no question of challenging. You can do whatever you want to do.
Yeah.
You are not taking away any of your liberties.
Well,
Item number 4.
Item number 4. I have filed a IA
you
in
also,
that.
I'm sorry, my lord. You also just refer to that Telangana judgment, my lord, that was also based on 3 Supreme Court judgment, and that judgment was also followed by the new changes. Lordship, just refer. I've given my lord along with the note.
Now you are crossing your limits, Mr. Counsel.
I'm sorry.
Item number 4.
My lord, I have filed an modification of the order. The order that regarding the NOC matter, my lord. My lord wanted extension of time. We have asked for 30th of August so that we can take up the matters for reconsideration, renewal and NOCs and dependencies pending before the authorities. So up to 31st, if the time is extended, we will accommodate everybody and we will consider the cases.
No, this was confined to only renewal of NOCs.
Yes, my lord. Yes, my lord. Yes, my lord. Renewal of
Renewal
NOCs.
of NOCs for such institutions
Yes,
which could not apply for renewal
yes,
because of the short period.
yes, my
Correct,
lord.
correct.
Yes, my lord.
Left
Renewal.
for
Yes,
them to
yes, my
apply.
lord.
That is only for renewal,
Yes, my lord. For renewal, we will give.
but that will not disturb your
My lord,
be done.
You'll see my indicate one thing. I have had a memo where actually I have indicated their time schedule they have given recently. If your lordship looks at the memo I have filed today, Lord, because they provided me that. The counseling will start from 1st August. Here they, after they give the NOC, I have to get the affiliation from the university. That's a formality in fact, but you have to make an application and get it. So that should also be expedited so that I can get it done.
So that you can.
That will be expedited. Let all the authorities cooperate.
Where is your IA?
Memo I have filed. They have filed the petition. Their documents I have filed. Their documents is, if your lordship looks at Indian Nursing Council first one, that is 29 January 24, where the entrance test, commencement academic session, last date of admission mentioned. Then the next page is notice to principals of institution for submission of affiliation. And my applications are also have the next stage.
This application has been filed seeking the court's leave to permit such institutions, nursing colleges,
Nursing, BSc nursing.
BSc nursing.
BSc nursing colleges to apply for a renewal of their
NOC.
which were granted for the academic session 2023-24. Post op. The application has been filed in the light of this court's order dated this application seeking leave has been filed in the light of this court's order dated
14/5/2024 and 28/6/24.
and 28/6/2024 in WPC number 398684 2023. Full stop. Next. The necessity of filing this application arose because some of the institutions, some of such nursing colleges were not in a position to apply for a renewal because the NOCs were granted soon before the process of making application for grant of NOC bracketed slash renewal of NOC had begun.
Yes, for 24-25.
For
24-25.
24-25 academic session to 2024-25 had begun. So stop. The situation faced by such nursing colleges has been the difficulty faced by such nursing colleges which had been granted a renewal, granted NOC for the academic session 2023-24 has been realized by the DMET also. And it is in that background that they have that DMET has filed this application seeking permission to accept the applications.
Yes, please.
Applications for a renewal of NOCs.
Yes.
By extending the time as was initially prescribed.
Yes.
Stop. Next. Considering the facts, learned counsel appearing on behalf of the DMET has submitted that if the applications for renewal of NOCs are entertained now, that will not disturb the timeline. That will not disturb the academic calendar.
Yes, admission to the course. Last date fixed by INC.
Disturb the last date fixed
By Indian
the
Nursing
court
Board.
for admission.
Yes.
For giving admission to the students. So stop. Next. Considering the facts and circumstances and in the interest of justice, this application is allowed. So stop. The DMET can accept applications for renewal of NOCs by
31st of
31st of
August. August.
up to 31st of
August.
August. When will you start your courses?
Course
will
start,
begin?
but the admission last date is 30th of September, my lord.
September. So August. First of It is however observed that the DMET shall be under obligation to put the necessary information on the website, on its website, so that all institutions interested in a renewal of NOCs may apply.
Yes.
So stop. Next. That is over.
Yes, ma'am.
Now your writ petition. This order has been passed. Now we come to your writ petition.
Yes, sir.
Is it something is left? Whether something is.
Sir, annexed 24, page 102, my lord.
To be passed in WPC number 398680. Yes. This
Page,
This order covers your case, I think.
my lord,
This order covers your case?
I think that will cover my case, my lord. I have filed application for rehabilitation because time for NOC was over.
so now that has been done.
Now it can be done, my lord. My application may be treated as NOC. That's also NOC. My application.
Yes,
purport-
you know, see, therefore, so this order covers your
Yes, yes.
grievance.
Right.
WPC number 5.
They have published a list where our college name is not there. They should indicate that.
No, now we will do it, my lord. Now we will do it for this year.
Sorry. If they will do it, sir, it's okay.
Oh, the list of those who
Yes.
have got NOC for this year?
Yes.
Obviously, because you are.
Yes.
My name is not there. They should
It will be
incorporate that.
automatically given, my lord.
Because of
Now,
this, it will.
now they will notify.
Yes, yes.
and
They
you can-
will notify them.
they
They
will
notify.
notify.
Yes. The reject one,
WPC number. Also.
consider it.
It is the petitioner. It is the case of the petitioner in the present rate application that it runs BSc nursing that NOC was granted to it for running BSc nursing course for the academic session 2023-24.
24.
Full stop. For on when? Do you have the dates?
When
was NOC granted?
16/1/24, my lord.
16/1/2024.
16/1/2024.
My lord,
16/1/2024. I'm sorry.
So, so
16/1.
it could apply for a renewal of NOC.
I have made the application, annexure 24, page 102, if your worship looks at it. I have said opening of link to apply for renewal of NOC cum recognition.
Applied, but it could not be registered, no?
It has not been entertained, but I have given a hard copy. They didn't
No.
open the link. Now they'll incorporate my name.
My lord, that is the NOC for enhancement of seat of 75.
Yes.
NOC was given, but this 16/1 enhancement of 70 seats renewal was given.
A renewal has been given.
Yes, that was been.
23/24.
But 23/24, that was not been accepted. Now he has to apply for that. We will allow his 75 extra seats.
For 24/25.
24/25.
No, for extra seats, it's very difficult. For renewal, we can permit.
Yes.
Just renewal.
NOC.
Yes, yes, NOC, see. NOC was granted for 2023-24 for
23-24, correct.
seats. You were required to apply for extra seats.
Yes.
You could have applied separately, not renewal. Renewal, that is not renewal, that
No,
is,
not renewal, NOC.
yes, NOC cannot be granted. Renewal you can apply.
NOC has to
Renewal
be
you can
fresh.
apply for that, for those seats, for those number of seats only.
Man seat should be fresh.
Comma, for 60 seats.
Right.
Stop.
Eh? 150.
For 75 enhancement of
75.
seats, 75 seats.
75 existing,
Yes,
75 more.
yes, madam.
Existing or?
75 seats.
75 more.
75. Stop. It intended to enhance the number of seats.
Yes,
For the academic session 2024-25.
25.
So that has already been enhanced, my lord. Enhancement has been done. After the enhancement was made, NOC was granted for 23-24 for 150 seats. And now they have to grant me 23-24, 150 seats. So that is the application which they have to entertain.
For 150 or 75?
150, 150,
Because for 75 you have got, because you're still continuing.
right.
75.
No problem.
No, no problem, but they are not entered in that.
75.
So the institution's application for a renewal of NOC
Yes,
would not be, has not been considered by the DMET
yes, right.
as it could not apply online
Yes, sir.
as per the procedure prescribed by the DMET. Stop. In view of the order which has been passed today in WPC number so and so, comma, in the court's opinion, the petitioner's grievance does not survive anymore as the court has directed, as the court has permitted DMET to accept applications for a renewal up to 31/8/2024.
Yes, ma'am.
Okay.
Yes, ma'am.
Can I just, with a little bit of liberty, can I say something? Well, here let's say the cause doesn't survive, cause has satisfied.
Grievance of the petitioner stands redressed.
Right, grateful.
Item 19 covers this case. Item 19
19 is
Covers is covered by this case.
is covered by this case.
this.
It is my GNM and my senior counsel case.
Yes, no.
BSc.
Your is GNM.
Yeah, no.
19 will be.
The fact is this, my lord. The respondent 3, without following the recruitment procedure, he has recommended the respondent 4 to the director for approval. And the director, without verifying the records, he has approved on 5/9/2023, and subsequently he has rectified the mistake on 15/9/2023. When the petitioner and others and the associates came to know there is no recruitment for the post by the DO respondent 3, they made complaint. And the respondent 3, let's see for the annexure 4, page 20. After verifying the files in his office, he has observed para 2. page 20, annexure 4. I'm allowed to read that paragraph. Letter dated 39/2023. I am reading the paragraph 2. Further, on verification of letter issued.
Where is the order of this court?
Order the page 38, annexure 10. And the concluding paragraph is page 45, paragraph 7.1. The court has held that the petitioner has not challenged the recommendation dated 28/6/2023, nor approval made in favor of the petition in other case on 5/9/2023. For which my lords has called for the records of WPC 42079 of 2023. In the prayer, the petitioner has specifically prayed for quashing of the approval order.
Who are you? We have not been able to understand anything, approval or
Sorry.
denial or
Sorry,
your
but
local stand-I, which has failed to be.
I'm going to the fact, my lord. There was a district science supervisor post are lying vacant in the office of
Supervisor.
yes,
Yes.
in the office of the respondent 3, district education officer Jaspur.
Yes.
The district education officer Jaspur, without making any advertisement to fill up that post, regular post, he has recommended the respondent 4 name to the director for approval. Because previously, the 13/7/2023, the director directed to all the inspector of schools of the Odisha, when they will fill up their post, they will at least send 5 senior most science teacher of the district to the director for consideration. But the respondent 3, the previous respondent DO, without following that procedure, he only recommended the respondent 4 name to the director for approval on 28/6/2023. And the director, without going his guidelines, has approved the recommendation on 5/9/2023. Thereafter, he has rectified the mistake. There is some mistake, clerical mistake, the letter number. Again, he has approved on 15/9/2023. And when the petitioner and others came to learn that without following the due procedure law, they have filled up that post, they have made complaint before the DO, director, and collector Jaspur. And the DO, after receiving the objections, let's see for the moment, page 20, annexure 4.
Who are you? How are you?
I am one of the selected teacher, science teacher of the district Jaspur. By page 20. After receiving the objections, the respondent 3 requested to the director, OP number respondent 2, on the ground that there is no corresponding file, note sheet, or any other relevant documents for the letter traceable in this office, which can point out about the manipulation. Consequently, application have been invited by such and such under 22/9 for interested science teachers of the government secondary school in the district of selection of district science supervisor, and the selection will be done after evaluating the biodata through the district level committee. And the same is under process, and after finalization of the process, it will be sent to the holder. In view of this, last para, the approval of the DSS post in favor of such and such in the Rambang Upnai School, Rambang, made in the version of 5/9/2023, and corresponding to 59 may be re-verified. Because in his office, there was no application of respondent 3, there is no note sheet, there is no
documents regarding
Your writ petition, one,
my writ petition is that is 420 of 7923.
so in which paragraph your case has been dealt with?
In the that judgment order, my lord,
Yes.
at the time of admission, it was dismissed on the ground that I have not challenged the approval order dated 5/9/23 or the rejection order dated 18/12/2023.
See, you are challenging this order dated 4/1/2024.
23.
So your writ application was also dealt with in that case.
Yes, in my case, it was dismissed.
Where is that? In which paragraph your case was dealt with? A case has been dealt with.
But that is paragraph 7, page 45, or writ appeal.
What was your writ petition number?
42079 of 23.
420.
42079 of 23.
So that had been disposed of on 4/1/2024. Order, you did not challenge the same, you filed a fresh writ application.
No, I have filed a petition to recall that order because of, without going through the
Yes.
documents, they have rejected.
So
It
you
was
have-
also rejected. Therefore,
Yes.
I have challenged
So-
that order and
So
rejected.
you had not challenged that order, for which the second writ petition, the learned single judge has observed that that order has not been challenged, but a fresh writ application has
Yes,
been
I
filed.
have challenged that order. That
Yes.
is that judgment.
When this other writ petition was disposed of, by the time you had not challenged. So after the learned single
One-
judge
one-
disposed, when the learned single judge disposed of the second writ petition, then you have challenged both the orders.
One day, two cases are listed. Both cases, one day. 42079 and 86 is,
And
86.
8161 has been disposed of on 1/5/2024.
115, yes.
42079 was disposed of on 4/1/2024.
And 15/2024.
That is the recall petition
Yes,
was
yes.
dismissed. But in
One day, two cases are disposed of.
no. No.
A recall petition
So
rejected.
that is not disposal. That is recall has been
Yes,
rejected.
rejected, yes. Because that the respondent
Yes.
3,
Yes. Yes.
totally he is not applied for that post. It is the information they have supplied, and it is the order sheet which shows of the respondent 3 in page 20.
I had got it. I have it here. State of Orissa versus RFP. I would have print out the with OG at. In fact, I've saved it here.
After recommendation, the respondent 3, he has filed a case, and this is the court directed to consider the representation.
No, to take a decision. If the
Yes,
matter is pending, to take a decision.
yes.
No representation is.
Thereafter, on 18/12/2020, the respondent 3 is rejected. And the court has taken a view that it is worked out.
so the first finding of learned single judge is that this guideline issued on 7/7/2021 is not a guideline,
It is not a guide, it is a draft guidelines.
it's a draft guideline.
Yes.
So there is no illegality in that.
Because, but there was a guidelines issued by the director on 13/7/2023. How to fill up that post. That is page 36 of my writ appeal.
Yes, what is the dispute? I have not been able to understand anything.
Yeah. So Lordship will have a glance to page 41. That is the order passed by the Honorable Single Judge. What was the prayer made by the petitioner before the Honorable Single Judge in the writ petition? Your Lordship may kindly see page 41, paragraph 4. The Honorable Single Judge has taken note of it. It is the case of the petitioner in WPC number 42079 of 2023.
So what is this system? What is this post? Science supervisor?
District Science Supervisor.
What is this?
That is a post in the, it is not a substantive post, but it is a post in the, where the senior most teacher from the district are appointed to remain as a district science supervisor in the office of the district education officer. Now, the guidelines that was relied by the petitioner, Your Lordship, that is why I placed para 4. It says, it is the case of the petitioner in WPC number 42079 of 2023 that in terms of the guideline issued by the government in the School and Mass Education Department on 7/7/2021 under Annexure 10, the selection and appointment of district science supervisor has to be made. Selection procedure as prescribed in the guideline is reproduced hereunder. Now he is relying on this guideline, my lord. Then Roman 2, the committee shall consider the merit and performance of the teachers in the list prepared in the manner as in para B1 and shortlist 3 teachers to be recommended to the state selection committee for final selection. But this is the guideline relied on by the petitioner. Now, what is the finding of the Honorable Single Judge? Your Lordship may kindly see. The finding that is at para 7. Your Lordship may kindly see. Para 7. Having heard the learned counsel appearing for the parties, after going through the materials available on record, this court finds that the guideline issued by the government in the Department of School and Mass Education 7/7/2021 under Annexure 10 is a draft guideline and no document is there showing that the said guideline has been approved. So this guideline is not an approved guideline which was relied on by the petitioner. So that this is the basic.
Okay, so did he have any other case?
Yes.
Different from his?
No, my lord, subsequently what happened after this order was passed by the Honorable Single Judge, Your Lordship, the date is very vital. The order passed in the present writ petition was on 4/1/2024. So subsequently, petitioner applied for certain documents under Right to Information Act and he obtained certain documents after disposal of this particular. Then he filed another writ petition. Now both this writ petition was earlier rejected, then the subsequent writ petition was not entertained, and that is why he has preferred this appeal. So that is why on last occasion 15/7/2024, Your Lordship have formulated a question of law that is to be decided. Your Lordship may have a glance to the order passed on 15/7/2024 in WA 1399 of 2024. That is the connected case.
WA
1399 of 2024. That is the connected case, my lord.
Yes.
A question has arisen as to whether the appellant can take advantage of certain information received under the Right to Information Act to assail a judicial order passed by this court in the writ proceeding. This is one. Then number 2, the fundamental question is as to whether information received under the RTI Act can be the basis for adjudication of the disputes by the court of law. So this has to be addressed.
Yes, you can see this. Have you examined this question?
But I have examined to the extent, my lord. So far as Right to Information Act is concerned,
Is there any Supreme Court's decision on this point?
no, my lord, this Honorable Supreme Court, in case of All India Hajj Committee, on the last date of hearing of that matter, when the judgments were reserved, the Supreme Court made certain remarks that the information obtained under the Right to Information Act is does not amount to admission of the state government.
Right.
So it cannot be utilized as a evidence in a writ proceeding. That is what the Supreme Court observed. But in the final judgment, nothing has been discussed to this effect. Only this particular observation of the Supreme Court, it came in live law, and so that. But as such, the judgment regarding I could not find any particular judgment, but I have examined under the Right to Information Act, though information and public authority has been defined, yet the evidentiary value of the documents obtained under the Right to Information Act has not been discussed, prescribed, has not been prescribed. So the document obtained under the Right to Information Act, being the photocopies, so it has to be treated as a secondary evidence in terms of the Evidence Act 63(1) and 2, my lord. And so far as the public document is concerned, so any photocopy or certified copy that has to be signed by the concerned authority to be as a true copy of that document. Here, the documents relied on by the petitioner, if your lordship will see, although those are obtained under the Right to Information Act.
This is what you are saying is about the document supplier.
Yes.
Now, suppose someone seeks an information that how many candidates had participated in the process of selection.
Yes.
And the answer is 20.
20.
No documents supplied.
No
Those were the
documents.
information.
Yes.
This is the information.
My,
So whether this information supplied will bind the government or will bind the person who the department from which the information was supplied. That is the question.
yes.
And there is a decision of Supreme Court from Odisha. So, could you get the equivalent section?
It's not opening, but I'll get it. I have it in my chamber.
So we'll decide the. But you are not satisfied.
Become. And the present case,
In this case, it had happened that after the writ petition was dismissed, under the Right to Information Act, certain informations were received, and thereafter the certain orders were passed based on the information which had been received under the Right to Information Act. The Supreme Court did not approve that.
what in this case,
But
With
in this,
what in the writ 1398 by 2024, in that case, he has not filed any document of information getting the information act. He has directly filed the documents of the authority. In the second case, in the next date, I have requested to add
see the conduct of your client.
Yes.
All right. You file a writ petition.
Yes.
Which is dismissed.
Yes.
Then you seek some information under the Right to Information Act.
Yes.
Then you file second writ petition.
Yes.
That is also dismissed.
Yes.
And now you are challenging both the orders.
But two orders, my lord. In the
yes, two orders.
Yes. In the first case, in the WPC number 42079, in that case, he has not referred any document of getting from Right to Information Act.
Mr. Counsel, that writ petition was rightly dismissed on the ground that you were relying on guidelines issued on 7/7/2021. The learned single judge rightly observed that that was not in the nature of guideline, rather it was draft guideline. So you are relying on draft guideline. So first dismissal is correct.
But the next line of that the judgment, my lords, in para 7, court has held thereafter. Therefore, the guidelines. Well, see page 45. My brother has stopped that after it was the guidelines has not been approved. Thereafter, page 45 in the same paragraph, paragraph 7. Therefore, in top.
These are the cases where the court should impose cost.
Para 7, my brother has read my letter up to guidelines has been approved, not the approved. Thereafter, the guidelines issued by the director on 13/6/2017 is to be followed with regard to the posting of science teacher as distance supervisor as found from the record. In terms of the guidelines issued by the director on 13/6/2017, though it was required to suggest 5 names, but the DO Jajpur recommended the name of the petition number in WP such and such for his posting as a district science supervisor on 28/6/2023. He is only recommended one. By ignoring the guidelines issued by the director on 13/6/2017. The previous is the draft guideline, draft rules. That is not a rules, as it was not approved. But the guidelines is dated 13/6/2000 has not followed. What has observed? He has only recommended only one name. And that guidelines is 13/6/2017. See for the moment, page.
So you could have challenged this order. You could have challenged this order before filing that writ petition.
Because in that case, I saw that this court had directed the 13/6, therefore he has filed a petition for recall that order or modification. And both the cases are listed in one day, and both are dismissed.
Mr. Counsel, this writ petition was disposed of earlier, which you are challenging.
4/1/2024.
24.
Yes.
And thereafter you filed a writ petition.
Thereafter, I filed an IA for modification of that order.
Then?
Modification of order dated 4/1/2024. And both the writ applications the disposal case by IA and the writ application 8161, both are listed on 1/5/2024. Both are dismissed on the same day.
It's very difficult, Mr. Counsel. That was dismissed earlier.
And the 4/1/2024, I admit, my lord. I have filed a
You
miscase.
will have to admit that was dismissed on 4/1/2024.
Thereafter, I filed a petition for modification of the 4/1/2024 order. And both the cases listed on one day.
Then you have spoiled the case of your client. Nothing can be done.
And see, for the moment that the guidelines dated
No more,
13/6/2017, page 36.
no more.
I only saw only two documents, thereafter I will go with my case, my lord.
You have been arguing for last half an hour.
I have not shown that two documents. Well, see, for the moment. But first will see page 26.
Page 26 or what?
That writ appeal. That
Yes.
will letter date 10/11/2023 of respondent 3.
Yes.
Two respondent 4. First, with reference to the subject cited letters cited above, I am to submit that consequent upon the approval of Kumar Snapde TGTCM Ramang Open High School at District Science Supervisor, Jajpur District Member of OSTA Jajpur and Jajpur Jilla Secondary Science Teacher Association read
So
objection.
you read whole letter?
No,
Yeah.
only that para.
Yes.
Only that para, first para. Objection regarding authenticity of this office letter number such under 28/6/2023, alleging that the same has been manipulated. Some other teachers also raised complaint before the collector and district magistrate Jajpur about manipulation, irregularity in the issuance of the letter for posting of district supervisor and submitted that the district science supervisor post being an important post in the district education office, selection of the teacher to the said post in a haphazard manner shall be detrimental for science education in the district and requested to follow a suitable procedure for selection of an efficient science teacher as the district science supervisor. Further, on verification of letter issue register of this office, it was found that the entry against letter numbers 7896/28/6/2020 was caught and re-entered, and no corresponding file, note sheet, or any such other relevant documents for the letter was traceable in the office, which pointed at the alleged manipulation. As such, the same was reported by this officer 30/10/93, 39/2023 to the DSC Odisha with a request to re-verify the approval of the report. The respondent 3 has a request to the director because there is no office file for selection. Still then the Honorable Single Judge has not considered the same.
How
And,
much?
and one judgment by the
Did you make your submissions on cost also?
no, I have not given the judgment.
Will you make your submissions on cost also, the quantum? Give. What should be the quantum? How much? You are a science teacher. Must be earning a lot.
Paragraph 16.
You are interested in litigation more than teaching.
Paragraph 16.
Yes. Yes, fraud.
Yes.
All right. This applies in all cases, 100%. Dismissed with the cost of type of.
Item number 6. This is the writ appeal against the order of the Honorable Single Judge arising out of a service matter. Now, the appellant, my lords, is NABARD, which is a national bank for agriculture and rural development. Now it is governed by its staff rules of 1982. We are just tendering the entire set of the rules. Now, the respondent who is appearing in person today, they are on caveat. He was terminated from service sometime in the year 2005. Against that, they came up before this court. Now, by virtue of this interim, there was an earlier round of single judge order. It was remitted back to the appellate authority. Appellate authority confirmed the order of dismissal. Against that, this writ petition was filed. Honorable single judge has directed him to be reinstated in service. Now, if your lordships would see, there are 3 rules in the staff rules which are relevant for the case. I'll take my lords to the impugned order, but my lords, the staff rules may be seen first. Each of them. The first rule would be Rule 44, which is at page.
That is about liability or loan or something.
Yes, madam. They have to disclose. Oh, this one. I'm sorry, my office copy has gone to the
Point which.
main point is there's a Rule 44 which says that they have to disclose about their liabilities. And
That is on the merits.
on merits.
Your main point is that if the court, learned single judge interfered with the order,
My lords.
then the learned single judge ought not to have directed for his reinstatement.
My lords. Now the honorable single judge, presuming the worst against my clients, the honorable single judge comes to a finding that there was a violation of principles of natural justice because the inquiry officer asked questions which were not germane to the issue.
No, it was not because of that.
Well,
It was because the inquiring officer started putting questions to the delinquents first. That was the reason.
No, in fact, the delinquent was not present. So this is a case where he avoided notice. He was not heard by the inquiry
No, but
officer at all.
There is something in the order. Where
Yes.
Where the learned single judge has noted.
Yes,
That-
that's the presenting officer.
No. That
So
the-
the
that
discussion in the impugned order is vis-a-vis the presenting officer and the inquiry officer. Because I'll make that good from the impugned order itself. And how those are, my lords, all errors of record, if I can say so. My lord may see it from the impugned order itself.
Can we see the produce before us the departmental the records of the departmental proceeding?
Yeah, they are
That
there.
is
They are very much a
easier.
part of the records.
Part of report.
Now, my lord may kindly see the impugned order begins from page 22. And from page 23, the factual matrix, the heading is factual matrix of the case. Here the factual matrix has been recorded. Then if my lord would see that portion which my lord was referring to, our submissions are recorded from page 26 onwards. Para 3. And the findings begin from page 28, para 4. Now, if I may show those portions which fall for consideration for your lordship.
Paragraph 4.
Paragraph 4. It is evident that the whole inquiry proceedings was completed by the inquiry officer by asking a single question for each charge. In the whole proceedings, this line, my lord may kindly take note, in the whole proceedings, the presenting officer has never presented charges. The inquiry officers have asked the question suo motu in the beginning of inquiry proceedings. The inquiry officer, by asking a question at the outset on the charge, has prejudged the allegations. The inquiry officer has played both the role of an inquiry officer as well as the role of presenting officer. Thus, the inquiry proceedings was not fair. So, now here, if your lordships may pause and come straight away to running page 114 onwards, which would show that these may be errors of record. Page 114 of your lordship's brief. which was a part of the records also before the Honorable Single Judge. So, if my lord would see Annexure 9 by the writ petitioner, page 112, the inquiry officer records about notice as to on what many occasions notices were tried to be served.
No, that we have seen.
That's besides the point. Now, my lord may see straight away 114. The error of record would be telltale from 114.
Yes.
After the heading, my lord may see inquiry officer name is given, presenting officer name is given, N. Sunil Kumar AGM, and stenographer's name is given. Then my lord may see that line. After a short brief of developments of the case, the undersigned asked the presenting officer to put forth the details of the charges against Sri DPS Malik, that is the present respondent, manager, the charge sheeted officer. Sri N. Sunil Kumar, presenting officer, placed all the charges made against Sri DPS Malik as under, and then the charges are placed. And documents are referred to. Next page that goes on. Next page 116.
Yes, do you want to reply? Do you want to file a reply to this?
My lord, actually, they have not produced a single document.
Maybe.
They
We
have
don't know.
not.
We don't know. It is up to you. According to him, the findings recorded by the learned single judge is there are errors on record.
My lord.
And for that, he is relying on this part of the inquiry proceeding.
My lord.
Do you want to deal with this aspect by filing a reply, or you want us to decide the matter on the basis of what is there on record?
My lord.
Will you file a reply?
My lord, actually, what I have already given a reply affidavit.
Reply affidavit he has filed.
My lord.
Yes.
All right. So there he is correct in his submission. The learned single judge has recorded that he acted, the inquiring authority, inquiry officer acted as the presenting officer also. He was putting the questions, and presenting officer did not place the charges.
My lord.
That is incorrect, apparently incorrect.
My lord, actually, if we go to the second day's proceeding, after that, 104.
No, second day's proceeding is not important. Please try to understand. If on the first day, had the inquiry officer started putting questions to you, the matter would have been different.
My lord.
But after the first day, when it had started, on the second day, yes, the inquiry officer would have put questions. So have you dealt with this aspect? That is
No,
not
my
a,
lord. Don't let, my lord.
in your reply, have you dealt with this
No, my
aspect?
lord.
You want to do that?
My lord.
Otherwise, prima facie submission appears to be correct.
My lord.
And whether the records of the disciplinary proceeding were there before the learned single judge.
My lord.
Were there.
Yeah, this is his writ, Annexure 9 annexed by him.
That is before the single judge, it was there.
This is his
If you
document.
want, you can do. It is submitted by learned senior counsel appearing on behalf of the appellant that there is manifest error.
Because there's a contempt filed against us. for the
Manifest
single
error.
judge.
Apparent error of record. Apparent. Apparent exceeding the impugned order passed by the learned single judge has submitted that there is manifest error of record in the impugned order wherein the learned single judge has recorded that the charges were not placed by the presenting officer before the inquiry officer during the departmental proceeding. And the questions were put by the inquiry officer himself. Stop. He has drawn our attention to the records of the disciplinary proceeding, which were also available before the learned signatures. So, prima facie, the submission advanced by Mr. Mishra and senior counsel appears to be correct. So, the respondent has entered appearance in person. Full stop. He intends to file an additional affidavit. Person. Full stop. An affidavit has also been filed by him in the present appeal. Full stop. He intends to deal with this aspect of the submission made on behalf of the appellant by filing an additional affidavit. Full stop. As requested, list this matter on so and so. Full stop. Still
7 days time, madam. My lord,
2 weeks.
may I draw your kind attention to the page 28 of the writ appeal? Page 28 of the writ appeal. Just I want to draw your kind attention. Para 5 says, without presentation by the presenting officer, without examination of the witnesses in support of the charges, and without identification of corroboration on the contents of any documents, the inquiry officer has proceeded to analyze the facts. So it is not the only fact that he has not presented.
This is the basic fact. And single judge records the one of the reasons why the learned single judge has interfered with the disciplinary proceeding is that the query officer acted as the presenting officer also.
My lord,
That goes to
my lord, so all these aspects has to be taken. Whether they have examined any witnesses, any documents has been presented, and
2 weeks to stop. Let this matter on 2 weeks so as to enable the respondent to file additional affidavit. So, in the meanwhile, the impugned order passed by the single judge shall remain in abeyance. Yes.
We are grateful to you. Maybe. But the petitioner is the appellant minor.
My lord, copy of the writ appeal, maybe.
Yes. But a copy of the writ appeal be served
By tomorrow I will give. By tomorrow I will give.
upon learned counsel for the
Union of India, CK Pradhan.
India course of the day. So this matter on 4 weeks,
Little earlier, my lord.
21st hours.
My lord, 21st order is, this is a
21st.
interim writ appeal against an interim order.
Yes.
For 21st order, this case is posted before the honorable single judge. For 21st August, this case before the single judge, this appeal against the interim order of an writ petition.
Because 1 week. No. Because WPC is listed on 21. So 1 week.
May it please, my lords. Lord, I'm appearing for the petitioner online.
Yeah.
My lord, this is a matter which had come up before your lordships and we had argued on the merits for admission at length when the other side had pointed out that the power of attorney of the person signing the affidavit was not on record.
Right.
My lord, we filed the additional affidavit which gives the full trail right from, my lord, the delegation by the board to the original power of attorney, then the sub delegation and the consent by the MD. All of those documents have been placed on record, my lord.
Yeah.
Now, my lord, if your lordship recalls, this matter is in relation to a penalty levied under Rule 83A of the Central Excise Rules. my lord, both the rule and the letter by which a refund has been rejected are in challenge before your lordships. The vires of the rule as well as the letter by which the refund has been rejected. And my lord, the facts are that the petitioner is a resolution applicant. The petitioner company has been taken over by a resolution applicant under the IBC provisions, my lord. And my lord, what had happened was that during the period June 14 to March 15, certain amounts were paid under protest by the petitioner in relation to penalty under Rule 83A. My lord, and that arose largely because of a delayed payment of excise duty, which was paid along with interest. These amounts were penalty amounts, my lord. Now, my lord, an audit was conducted. They wanted a higher amount of 8 crores and 5 lakhs and odd, and requested for a payment of 4 crores for 41 lakhs beyond the 363. And finally, my lord, an audit report is issued on 1st of June 2016, which is A5, page 80. And in that audit report, my lord, they say that a show cause notice will be issued to me, the company, my lord, which was held by the erstwhile corporate debtor. In terms, they say show cause notice will be issued to me. Nothing is done, my lord, for all these years. Thereafter, my lord, the company goes into the CIRP process under IBC. The department files a claim because this is an advance. There's no question of a claim on this account. And ultimately, the plan is approved by the NCLT on 15/5/2018.
So, Mr. Gulati, let us be clear whether you are,
Yes.
we should hear you on the point of validity of Rule 83A first or on the other aspect? Because we have challenged the virus. So
Well, no, both will arise. I'll explain why both will arise simultaneously. Correct. My lord, both will arise. Why I say so is this. My lord, the basis of the impugned letter is, our case is that this is an amount payable under protest, and absent any adjudication, absent any show cause notice, this was just lying as an advance to you, before you. And that advance is an asset of the company which I am liable to get back. That's my short case, my lord. The impugned order, my lord, goes on 3 bases and says that because my claims were partially settled, I will not return this. My lord, this has nothing to do with claims. Claims are, yes.
Whether without entertaining your challenge to the virus of the rule,
Yes, my
can, the relief which you are seeking can be granted.
I was just coming to the second point, which the impugned order, that is the cause for the challenge to the virus. The second point, my lord, in the impugned order is that Rule 83A is automatic. So it doesn't require any adjudication. And that is the challenge to the rules. That is why the rules are in challenge, to say that this cannot, a penalty unless levied by way of an adjudication can never be imposed. It's not like a tax that the taxable event has occurred and therefore the tax becomes due. A penalty is always has to be levied by an affirmative order with reasons. And my lord, these are penalties which are being levied under rules. The Act itself does not provide for a penalty which can be levied without adjudication. On the last occasion, I had referred to your lordship section 33, which provides for adjudication of penalties and, my lord, confers powers on specific officers to adjudicate penalty. Then, my lord, the Act says that where there is no penalty specified under the Act, then by rules you can only have a maximum penalty of 5,000 rupees. This penalty, if construed in the manner in which the impugned letter has construed it, will go completely beyond the provisions of the Act. So this is the cause, my lord, for challenging the rule. Yes.
This rule was brought when? 83A?
My lord, 83 has been on the record book. In fact, my lord, earlier what had happened is that we had challenged this rule in an earlier writ petition before your lordships. At that stage, the resolution, my lord, had happened. Your lordships disposed of that writ petition, saying that it seems that the issues have got resolved. But if you have anything else left, if you're aggrieved, we give you liberty to come back. And that's the third point in the impugned letter, saying that your your writ petition was disposed of as infructuous, therefore no question of giving you anything. My lord, specific liberty was reserved in my favor by your lordship's order to come back if there were issues which remained. And that is why, my lord, if your lordship sees that order, annexure A10, page 249, your lordships clearly said that permitting the petitioner to file a fresh application if any cause of action survives.
Which annexure? Which annexure?
My lord, this is annexure 10, page 249.
Yes.
And the subsequent development, my lord, has been referred to. That is the approval of the resolution plan by which, my lord, I have taken over the company as a resolution applicant. And specific liberty is, my lord, reserved in my favor to say that if the cause of action survives, or then you have a liberty to come back. And this point, my lord, that if I have an asset, my lord, what does a resolution applicant pay for? He pays for all the assets of a company to carry on the business as a going concern. What is extinguished under section 31 of the IBC are only liabilities. This is money lying. Supposing, my lord, this was not the department. The company, my lord, there was somebody who owed something to the company. Money is lying with that person. I as a resolution applicant am entitled to recover it back because I'm running this company as a going concern. I paid for all the assets of the company to run it as a going concern. So, my lord, it's a very important question to say that you can't rely on the extinguishment of liabilities. Only the liabilities get extinguished, not the assets. If the assets were to get extinguished, why will I pay for anything, my lord?
Yes.
My lord,
So-
I have a small submission, my lord. Last occasion, my lord, senior submitted that you will file an affidavit. And I raised a point about the maintainability, filing a resolution, all these things have taken time and should required to be filed. I did, but I didn't receive the copy of the same. If you had to file or not, I don't have enough.
Oh, yes, file. Yes, file an affidavit.
It's on record, my lord. He's been served. A copy has been
But
served. It can't be
I didn't
filed
serve the
without
copy.
service.
My office had not received the same.
That was just technical, Mr. Padi.
Yes, it's a technical issue as regard to the filing resolution.
And
That,
that is there. That is now there on record. Yes.
My lord, it's an extremely important point, my lord, for your lordships to consider. In fact, and no court has actually delved into this aspect, both on the IBC aspect as well as on the nature of these penalties.
So let the Union of India file affidavit.
Yes, sure, my lord. There's no interim order I can seek, my lord. Let them file an affidavit, my lord.
Or Mr. Gulati and senior counsel appearing on behalf of the petitioner. And Mr. Padi, DCG and DSG representing the Union of India. Stop. How much time will you take, Mr. Padi?
my lord, Mr. Satpathy might have filed the GST.
I am appearing to Lord, 2 to 6
Will
in
take
this
3 weeks time. Yes.
2 to 6 I am appearing in this case.
Yeah. 2 to 6. So what is 2 to 6?
I mean, the commissioner, GST and central excise, and assistant commissioner and the superintendent audit.
This is around 4 weeks.
Local revenue of trade is very.
4 weeks?
Yes.
Yes,
But
yes, fine.
maybe slightly not on the first issue is not the, if you also see this section 83A and the penal provision.
He is referring to Rule 83A, not.
Yes, correct, Lord. Rule 83A.
Rule.
Correct. 2002 rule. I understand, Lord. Rule 83, Lord, the mode of payment. If you lordship see
File your
the,
affidavit since he has challenged the virus.
yes, Lord.
And then we will consider and.
There's opted to pay and there's declare is in his return, then penalty imposed, Lord. That is straight jacket
Let us-
formula.
Let us see.
No.
Your Lordship, please.
Let us.
Deeply obliged, my lord. Deeply obliged.
And counsel for the opposite parties to file counter.
Item number 9.
Conducting counsel be valid not well. Conducting counsel be valid not well. So kindly taken up on Thursday or Friday.
As requested to the matter on 2 weeks.
Item number 10.
The petitioner here, he was a bidder concerning a tender notice. The tender notice stipulated a clause, if at all there is abandonment of a work or the work in the midway, within 5 years from the date, last 5 years from the date of tender, he is supposed to submit an affidavit along with the tender paper. Now he submitted an affidavit along with the tender paper saying that none of his works are rescinded, nor he has abandoned any work. Now, after that affidavit was submitted and tender paper was submitted, in the technical assessment, financial assessment, the petitioner was classified as L1.
L1.
So at that point of time, a rival bidder came and submitted a petition that he has been blacklisted. My client is blacklisted by Gujarat Sardar Nigam Corporation in one of the work. That he submitted a letter to the department. Now, department wanted explanation from me. I explained them, saying that the work pertaining to which my rival trader is submitting petition, I have not been blacklisted. I had approached the Gujarat High Court in that matter. There was an interim order passed in my favor. Finally, Gujarat High Court gave a finding that there is no requirement of blacklisting the petitioner. The reason being, petitioner was not awarded with any work. It is his close friend was awarded with the work. But in the process, my petition with that observation got dismissed. That order is here with me. And I explained this to the authority. My explanation is with the authority.
Your petition was dismissed or allowed.
Because
Because
there is no requirement of black. That observation is there. So with that observation, since there was no cause of action, my petition was dismissed with an observation that if at all there is any kind of misappropriation or any, it is up to the government to lodge FIR with the CID, police or whatever. That observation is also there in the order I have given to them. Now I explained this to the authority. Now the entire matter is pending with the authority and they are not finalizing the matter. So that is how I am before today before finance.
Lordship may see page 79, annexure 7, Your Lordship. I may read out, Your Lordship. With reference to the subject cited above, it is to intimate you that.
no, what he is saying that you consider decide
That's-
whatever.
Yes, Your Lordship, please pass it.
I'll not pass that order. We will actually. In 2 weeks.
Let them just find whatever decision they
This matter on 2 weeks so as to enable an AGA to file a counter affidavit.
Correct.
So while filing the counter affidavit, you may take a decision.
that will end the matter. Either way, let them take a decision, either to reject it or whatever it is.
Item 11.
Great.
The similar matters are coming tomorrow at 2 o'clock. Let it come with that because he has refused to go for inspection. We went for online inspection and they have refused on please that we will not give us some time. Let it come tomorrow. 2 o'clock.
Give the,
Yes, my lord. 15883 of 2024.
yes,
And item 18 also same.
18. 18.
Yes, ma'am.
Item 12.
May I please be? Here the present petitioner institute has been approved in the year 2009 under the AICP, so also to be appealed under Annexure 4. And it has continued till 2023-24. They have issued notice under Annexure 9 for application for the provisional affiliation. I have applied and deposited the cost under Annexure 10, 70,000 for the same purpose.
Affiliation.
Affiliation for the 24-25.
You have been granted approval by AICT.
Unless, my lord, that AICT approval up to 23-24. That is under Annexure 8 series.
So what do you want now?
Now I want, my lord, they have to provide me the password and ID to upload my datas. They have not provided, even though they have received the amount, or provide the
required?
datas. That BPUT.
Who are required? BPUT.
BPUT. Under Annexure 10, I have sent my grievance to open the password and ID. Still, they have kept mum. And in the
Whether you have been granted affiliation.
application 23-24, I have granted the application. For 24-25, I have applied. I have applied the same. Under Annexure 12, my lord, I have
Use for the BPUT.
the
If you notice.
panels of advocates there.
I think Mr. Satpathy appeared today. Mr. Satpathy
But yeah, Satpathy is also appearing.
appears he was here.
Tomorrow.
I
We'll take up.
will survey of extra
Please
copy.
ask. Yes.
Item 13.
Lord, I'm on behalf of London Council Sri Om Swarup. Sir is in another court. I'm seeking to post this matter after 2 p.m. my lord.
2 p.m. No, 1 week. Please.
Is there any urgency? We are keeping it to next week.
Item 14.
Item 14, Lordship, on behalf of Mr. Bangshida Bag, Lordship. Lordship, pray for the matter to be taken up after lunch, Lordship.
1 week.
Lordship.
Item 15.
15 application has been filed. Praying for a direction to the opposite party number 2 to 4 for allowing the petitioner to appear in the second semester of 3-year LLB course, which was to be conducted on 9/7/2024. During the pendency of this writ application, the opposite party number 4 issued a letter to the petitioner directing him to that she was promoted to 3rd semester and she was also is permitted to appear the 1st and 2nd semester examination as back papers. So,
So
under
your
this,
grievance has been redressed.
yes, ma'am. Therefore, the petitioner does not want to proceed with the case. Matter may be withdrawn.
Counsel appealing on behalf of the petitioner seeks permission to withdraw this application. Withdraw this petition
Memo.
in view of the developments subsequent to filing of the writ petition. This application, the writ petition is dismissed as withdrawn. Yes. Memo is taken on. Yes.
Item 16.
Item 16, my lords. My lords, it was posted on Thursday, my lords. My lords asked me to array State of Odisha as a party. State of Odisha as a party, my lords. I have filed an IA on Saturday, my lords. That at IA I have filed and a copy has been served along with the petition to the Office of the Honorable Advocate General. So, my lords have complied, my lords.
It has been stated
that
by
only-
the counsel for the petitioner that an interlocutory application has been filed. Is there on record?
No, my lords, it is not yet on record because the file had already been sent to the court on Friday, my lords.
It is not there.
I have a copy, my lords. I can share. Yes.
With this matter on Monday with the state interlocutory application order.
Item 17.
It's interim order to continue, my lords, in this matter. Not sure.
May I please your lordships? Lord, may I just state the point for my lord's kind consideration and then I'll develop it. Lord, there's a lease arrangement between the parties, which is in the nature of a contract. And we had an EC, my lord, which was valid for a period of 20 years. And we also had a forest clearance. All three read together confirm my right because the lease and the EC were coterminous for a period of 20 years. The issue which arises for my lord's consideration, which I'm going to develop, is that they wrongfully suspended my mining operations and thereby truncated the time period and curtailed the term by 5 years and 10 months.
What is the period?
Yes, for a period of 5 years and 10 months, my lord, between 1st April 2014 and 31st January 2020.
Yes.
But the icing on the cake, if I may use the word, is that the Supreme Court itself allowed resumption of mining, in which case the statement of the government is also recorded that they had no objection, my lord, to the resumption of mining. And then the state government itself passed a resumption order on 31st January 2020, which is at page 295. So I'm going to show all this. The mistake which has been committed, my lord, by the government was that there was a subsequent EC of 2008, but it was a conditional EC. So that EC never sprung to life because that condition of obtaining a FC was not satisfied, and the Central Empowered Committee itself has acknowledged it. So the moment I'm able to show that my contractual right, supported by a valid EC, took me for a period of 20 years, and that the 2008 EC did not spring to life because there was a condition precedent which was not fulfilled, my right remains intact, which means I get the full tenure. And fortunately, my lord, a clause in the contract which I'm going to show you, clause 4 part 9, as well as, my lord, 12(1) FF, use the word this period then gets added back. So the moment I'm able to show I have a right and it was wrongly curtailed or illegally suspended, my lord, that unlawful interruption by contract and statute gets added back. So may I just...
How do you establish?
Yes.
That this period, the suspension for this period was wrongful?
Yes.
That is the only question.
Absolutely. That's why I said it's a short point. I've just given you the conspectus and I'm able to hit the nail on the head by showing one simple thing. Suspension order relied on a 2008 EC. I was governed by the 2004 EC, and the CC itself has said that because the condition in the 2008 EC was not fulfilled, therefore it never sprung to life. So it actually boils down to that, coupled with the order of the Supreme Court, my lord, which was passed on 15 January 2022, directing resumption of mining with no objection from the government, and their own resumption order of 31st January 2020 at page 295, which I'm going to show, at a small princely cost of 933 crores. So everything, my lord, has happened. So once I show you the resumption order, that itself shows that they were wrong, but I'll show you from the document itself. Now, if my lords could kindly have page 134 to start with.
Just one moment. You mentioned something that something is pending before the Supreme Court without giving much details. Paragraph, page 8.
Yes.
Paragraph.
I'll come to that. That's a slightly separate issue. It is not covered by this. I'll come to that. Since my lord asked me about the suspension order and what is wrong, if you permit, may I just show that first so that we know exactly what they said and the error. That's to be found at Annexure 9, page 169.
Yes.
We would kindly have the date 31st March 2014. And my lords will note it says, I am to say that the validity of the EC dated 29/10/2008 for production of 15 MTPA in respect of your iron ore mine expired on 31/3/2014. You are therefore requested to stop all kind of mining activity. Correct, Manoj? This is the suspension order. Now, let me show you page 140, which was the valid and subsisting EC, which is to be found at Annexure 7, page 139.
Yes.
But please note the date 22/9/2004. If my lord could straight away just for the moment turn to capital A specific conditions at 140.
Yes.
And my lord will note it says environmental clearance is for 20 years and fresh clearance would be required at the time of renewal of the lease. So my lord, this and the lease were co-terminus for 20 years till 13th August 2021. The mistake they commit will be evident from page 161. I'm showing the at page at the moment. It starts at page 159.
Can we resume after?
Yes, it is about resumption and we'll resume after lunch. Very grateful. May it please your lordship. Lord, now I'll just take my lords in sequence. Lord, your lordship will have page 97 first.
Yes.
That's the lease agreement. Just to tick mark.
Which annexure?
Lord, it starts at page 96, annexure 6.
Yes.
Lord, at page 97, your lordship will just note Form A, Lord, it's a statutory form, mining lease, and it's dated 14th August 2001. First line at
Yes.
page 97.
Yes.
And my lord, at page 98, if my lords will just note the last 3 lines, it says is hereby granted to the lessee from 14th August 2001 for a term of 20 years. Just mark this 20 years, my lord,
Yes.
at the end of 98. So, my lord, that is the lease. Now, my lord, please have page 139, annexure 7, which is the EC. According to me, the subject EC, the correct EC, the valid EC. That's to be found at 139. If my lord notes the
Yes.
date 22/9/2004.
Yes.
And suffice for this case, capital A small 1 at 140. The environmental clearance is for 20 years and fresh clearance would be required at the time of renewal of the lease. Now this, why I showed page 98 to my lords, 20 years. So only at 20 years, 13th August 2021. So this is, and just tick mark page 92, there was also a forest clearance, not relevant for today, but just 21st June 2001 for completeness. At page 92, your lordship may just only note. So as I said, my lord, all was well. Now, my lord, comes page 161. Starts at 159, annexure 8. Annexure 8.
Yes.
29th October 2008, 159. And my lords will just note at 161, capital A, Roman 3.
Yes.
Environment clearance is valid up to the year 2013-14. Working of the mine beyond 14, based on the established reserve, shall be commenced. Now, this is the governing word, only after obtaining prior clearance from the Ministry of Environment and Forests. And just have 2, EC is subject to grant of forest clearance. So this clause made it conditional, my lord, and getting the forest clearance. And when I show my lords the MOEF own document saying this condition never sprung to life, the author is the best judge, which will clinch it. But I'll do it in sequence. So, my lord, this is just mark. This is where the error lies when I come to the suspension letter. I'll show my lords. The reliance is on this which did not spring to life. Now, my lord, who better than the MOEF itself, if my lord now turns to page 253. This to me, in my respectful submission, would be the clincher for my lord's consideration. 15 January 2015.
Which annexure?
Annexure 14. 253.
Yes.
Lord, kindly read first para, third line. The petitioner was given an EC on 22/9/2004. My lord, the one I placed for my lord's consideration. Yes. For mining 4 MTPA, so and so and so, of a mining lease. Now, my lord, kindly see, the EC is valid for 20 years and fresh EC would be required at the time of renewal of the mining lease. So I pause for a minute. I've shown you both documents, the mining lease and the EC. Further EC for expansion was issued on 29th October 2008, which I just showed. Now kindly see the next time. EC was issued for a capacity of 15 MTPA subject to the forest clearance, which is yet to be accorded. So, my lord, that conditionality which my lord saw at page 161, if my lord just cursorily comes back to 161 again for a minute, which is annexure 8.
Yes.
EC will speak only after obtaining clearance from MOEF. And MOEF on 15 January 2015, the master of ceremony, so as to put it, the author, my lord, says it has not been given. With this, please have the suspension letter at 169, which is the bone of contention. And my whole case hinges on, as my lord rightly put it, annexure 9 at 169. May I, with my lord's permission? Kindly note, my lord, suspension of mining operation. With reference to the subject, I am to say that the validity of the EC dated 29/10/2008 issued by MOEF in respect of your mine expired on 31/3/2014. You are requested to stop. This offends, my lord, the MOEF letter, which itself says it never sprung to life, and it is based on the 2004 EC, which, as my lord noted, is valid for a period of 20 years co-terminus. So this is on ex facie wrong. So first error I'm pointing out. Now, my lord, pre-lunch I had indicated there was an order then passed by the Supreme Court, where in a light-hearted manner I mentioned resumption. If my lord has 291, starts at 289, annexure 18.
Yes.
Yes. Sorry, I made one mistake. If you would just give me the indulgence. This Supreme Court order came because of this last part of 253 annexure 14. If I may just request my lords to kindly go back to annexure 14, 253. My mistake. I apologize.
Yes.
I'm very sorry, madam. Second paragraph. In view of the above, the matter has been examined in the ministry, and it has been decided that permission to mine as per the EC condition of 4 MTPA is approved. That is, my lord, 22/9/2004, which was the live one. This is what MOF is saying, subject to permission from the Supreme Court. This permission to mine is in terms of the EC of 22/9/2004. Now come to the Supreme Court, my lord, at 289. So MOF says, go ahead, subject to Supreme Court. Supreme Court, my lord, on 15/1/2020, annexure 18 at 289. At para 4, page 291.
Yes.
In the light of these observations, the petitioner contends it's suffering irreparable injury and highlights how it has already lost more than 5.5 years and how hardly half a year of its lease is left. Expressing willingness to furnish an undertaking and bank guarantee equivalent to the dues assessed, the appellant seeks permission to resume mining operation. Upon notice, the Council for Orissa and CSE expressed no objection for granting SMPLs, that is the petitioner's prayer, for resumption. So, my lord, no objection, consent given for resumption. And this, my lord, is followed by the state government's own letter, as I said, 295 annexure 19, 31st January 2020. With reference to the above subject, my lord, that is the Supreme...
Which annexure?
My lord, annexure 19, page 295.
Yes.
31st January 2020, page 295, with reference to the above subject, as per the order of the Supreme Court and as per the instruction of the Director of Mine, you are hereby allowed to resume mining operation in respect of your area. That is, my lord, the EC of 4 million tons. So, my lord, with greatest of respect in you, and I have a direct judgment also, but today it's only for notice. It's clear that this is an absolute error which is committed and acknowledged now in the Supreme Court judgment and the resumption order which they passed. And therefore, my lord, this period has to be added back. That, my lord, is the short point for admission.
File affidavit.
Well,
All right. How much time?
2 weeks, my lord.
2 weeks?
Yes, ma'am, certain. Every day counts heavy, so the early.
Third and senior counsel appearing on Mr. Gopal Jain, senior counsel appearing on behalf of the petitioner. And so AG, you are
Mile.
AG
Mile.
representing the state of Odisha. So stop. List this matter on 2 weeks. Within first 5 cases. Let in the meanwhile, detailed counter affidavit be filed on behalf of the state of Odisha.
Yes, just one line, my lord, in case required, a week for a rejoinder, just in case required.
Then we can adjourn it for 3 weeks.
Yes, ma'am, after 3 weeks.
3 weeks. 3 weeks. First 5 cases. Let a counter affidavit be filed on behalf of the state of Odisha by 2 weeks. Stop. Time in the meanwhile may be utilized for the petitioners to file a rejoinder affidavit if so advised.
So very deeply grateful. Okay, but would your lordship be giving a fixed date if it?
Yes, please.
20th August.
20th.
20th of August.
Extremely grateful. Very good. Lord, can I kill 2 birds with 1 stone? Serial number 37 was listed at 2 p.m. today. Your lordships had directed on 2nd July that they had to file a detailed counter affidavit. I believe it's just come.
No, today, I'm sorry, my lord. Today I have filed, my lord. I've already solved a copy.
So you want adjournment?
Yes, I was engaged in resumption, not having chance to.
Item 37. We are very impressed by your sense of humor and
Always good to have light-hearted moments and get the job done.
Item number 37.
Item number 37.
Yes.
With the lordship's permission, my lords, same matter. I have my colleagues from Delhi, so can I have their names on record? If your lordship permits that matter itself.
Yes.
Deeply obliged.
It is stated that a counter affidavit has been.
Ma'am.
You have filed or you have?
I already filed, madam. Hard copy with me. I have already filed, refiled.
Has
Hard copy with
filed
me.
on
Ma'am.
behalf of the state online. Oh, there.
Online, I have filed, already filed.
Online.
And I am also filed hard
A
copy.
copy of
In court
which
today.
has been served upon the counsel representing the petitioner today itself. Stop. As requested by Mr. Counsel and senior counsel, list this matter on same day. Same.
Whatever is
20
convenient.
Ma'am.
10 days for rejoinder.
We are adjourning this case also on the same day.
Very well.
All right.
Yes, ma'am.
So in the meanwhile, you can file rejoinder.
Very well. We'll do that. Extremely great.
Meanwhile, if required, rejoinder may be filed on behalf of the petitioner.
So deeply great.
Item number 20. Item 21.
application, this appeal has been filed under section 19 bracketed 1 bracketed A of the Contempt of Courts Act, putting to challenge an order passed by a single judge dated 19/2/2024 in UNTC number 7037 of 2023, whereby the contempt petition has been dismissed. Stop. Next, in the court's opinion, the appeal is not maintainable as it is against an order passed by the land single judge dismissing the contempt application. So, it is dismissed accordingly.
Item 22.
I may be pardoned to appear on VC, my lord.
Yes. Order has
My
been.
lord, Mr. Rathod, conducting counsel is not well actually.
No, it has been
That-
complied with, Mr. Counsel.
Yes, my lord.
Your lordship, he has to add something in this argument, so
What
1 week
something in this?
adjournment.
No. Let us see the order. Let us see the order.
Your lordship, we haven't got the compliance affidavit, the copy of the compliance affidavit.
Yes, it has been complied with.
Yes, sir.
Your lordship, 1 week time.
Passed by this court violation of which has been alleged in the written contempt application. Following is the order dated 28/6/2023 passed in WCC number 19059 of 2023, violation of which has been alleged in the written contempt application. Stop. An affidavit has been filed on behalf of the Additional Assistant Commissioner of Endowments, stating therein that in compliance of the court's order, the Additional Assistant Commissioner of Endowments, Cuttack, had sent a report to the Commissioner of Endowments towards indexing the institution after having made due inquiry institution के बाद comma after due inquiry having been made by the IE Jagat Singhpur, followed by its report dated 17/5/2022. Stop. Taking into account the said later, the Commissioner of Endowments has passed an order on 13/5/2023. Stop. The order was communicated to the petitioner. The order has been communicated to the petitioner through letter number 1266 dated 10/6/2024. Stop. Next, considering the statement made in the compliance affidavit, we are of the considered view that no case of intentional disobedience of this court's order is made out. Contempt proceeding is dropped. Yes.
Orders item 23.
May I please your lordship, my lord. This is a case under section 302, 34 IPC, my lord. RI for life and 5,000 rupees fine, my lord. And the co-accused Prashant Ghade has been released from by this honorable court on 13/5/2024, my lord. Kindly be viewed, my
But you are in custody since when?
lord. 6/7/2013, my lord.
6/7/2013.
13, my lord. No chance of explaining, my lord. Follow it. Three times.
So this is, your IN number is 404.
Yes, my lord.
Huh?
Yes, my lord.
404.
404 of 2023 for bail, my lord.
404.
Has it been rejected earlier?
Yes, my lord.
By which bench?
Oh. 6/1/2025 was there and this is back.
Therefore. You and it's the
27/4, Honorable Justice Das and Honorable Justice Panigre, my lord.
Also.
Huh?
When?
27/4/2024.
27/4/2024.
My lord.
Can't
He
be.
filed interim bail. It's, because of course, for interim bail, he had filed an application for interim bail that was rejected.
Well, also.
And bail for regular bail was, sorry, no, bail was rejected on 6/1/2022. I'm extremely sorry, my lord. Honorable Justice, your lordship sitting with Honorable Justice C.R. Das.
Therefore, it has been placed before.
Before lordship, my lord. Yes.
It's all round.
What is the nature of allegation?
So in fact, there are witnesses. Only my friend is relying on the release of co-accused. Only I will pray, my lord, my friend may give me a copy of that order.
Oh, just what is
My lord, there are witnesses, my lord, PWs. My lord, so
what is the allegation?
allegation is that while the my lord, disease was going, my lord, all these accused person among my lord, numbering about 5 to 6. My lord, chased him, assaulted him by means of sword and he died, my lord. So if the allegation so far as the person who have been released on bail and the president is the same, my lord, I will verify, lord, may take it out tomorrow or day after.
No, we are not granting him bail on that ground. We on the ground of, you see, he has been in custody for last 11 years.
That your lordship may consider. There I will not. Well, because the lordship similar grounds, lordship will consider the bail. There I will not.
After having been convicted of the offense of an offense punishable under section 3 and 2 of the IPC, the but you will have to file your objection. Have to give you-
The 389 one petition, lord.
Yes, provide.
One chance for you to.
Next week, lordship, next Monday, I will try to file it within that date. If not, lordship may pass.
With this case on 1 week. So as to enable an AGA to file an objection in terms of the proviso to section 389 bracketed 1 of the CRS.
Connected is same.
Huh?
Connected appeal also same prayer. Bail.
Connected
Connected,
appeal.
he has been granted bail.
In connected appeal, my lord, Prasad Ghade has been granted bail by this honorable court on 13/5/2024.
Then why are so many applications IAS pending?
That is already disposed of,
No,
not pressed.
48 of 2021.
Only I want to place the only 404.
So this order will be passed in the first or second one?
My lord. Sorry.
Only Lords in appeal number 36/2021, in IA number 404 of 23.
That's all right. Look at the second appeal.
Second Lords, I think last bail was granted in 1049 of 2024 Lords. The order I don't have, I think there is order has been passed now. Because the last in item of the criminal appeal 48/21, the last IA for bail at flag E 1049.
That is not pressed. Withdrawn, my lord.
Oh, but this is unfortunate. All these IAs have been disposed of, but the office is still listing these cases on 13/5/2024.
That will same copy paste.
Because those IAs have been disposed of as infectious.
Oh.
No, sir. 13/5/2024. 1, 2, 3. 3 IAs disposed of, doesn't want to press, disposed of as not press. And 1049 has been,
Allowed Lords.
and all those have been shown today.
That is operated.
Hmm?
This load is not operated.
Yes, no, they are not page marking the annexures. I don't know what has happened.
Who does that?
No, these petitions, they have not page marked the annexures. Eh, why, correct. So, intermittent, when they are given form,
No.
I don't agree.
Next week.
Sorry?
Income next week.
इसमें तो no problem. इसमें तो they have it for updating.
Oh, yes. Oh, general. General.
Ah. Well, probably means you don't know.
Item number 24.
I beg your pardon, Your Lordship. Item number 21, I may be excused, Your Lordship. I could not reach in time.
That contempt appeal,
Yes, Your Lordship.
we have discussed
Your Lordship, I may be allowed to place the
as not maintainable. Because the appeal lies against an order when the court takes action. When the court refuses to take action, then appeal would not lie. That is the law.
Your Lordship, the court has dismissed the contempt petition, Your Lordship.
So had the court punished or had the court held someone guilty, then appeal would lie. Otherwise,
That is the provision.
Your Lordship has passed orders, Your Lordship.
pass. No, we have not recorded your absence.
Your Lordship, my presence may be recorded.
24.
Yes.
Item heard, I am for the appeal in matter 38.
What for it has come?
Advocate Shankar Mahanti has probably filed, his name appears in the website.
He is in file 146/24 for modification.
By another council.
Yeah, another council. I am for the appellant.
He's filed a
This-
memo mentioned, but not.
Because non-compliance of the order passed by the Honorable Court for 24/4/23.
Yeah.
There is no representation on behalf of the applicant. This matter on.
The copy has not been filed.
Item 25.
Railway dispose of or urgent?
No, this, what you have.
Oh,
That's fine. Item
withdrawn.
25.
Item 25. Withdraw. Withdraw.
Withdrawn.
Well, memo is there.
Withdrawal memo filed by the council.
Well, withdraw. Item 26.
In this case, notice has been issued on the question of limitation. That matter relating the counting of past service during the job contract period. And that matter is pending before the Honorable Apex Court. In similar cases, your Lordship has and the Honorable Apex Court order.
Item
My
20
learned friend has appealed for respondent.
Item 27.
Wait, please, members. Page 29 is the impugned order of the Honorable Single Judge Minutes. Wherein on the minutes, it was allowed, but I am appearing for the university, my lords. We were not heard. Your Lordship will see the order. It was disposed of. It is contended that the issue involved in the present writ petition is covered by an order of this court passed on 11/9/2023 in WPC number 4557 of 2015 and batch. So confirmed by the writ, appellate court in writ appeal, so and so.
Yes, we are issuing notice.
Minutes? There's a 19-day delay. He's in the next matter. There's a 19 days delay, my lords.
But delay will have to be condoned.
My lords.
And for that, we may be required, we should, both, issue notice.
Somebody has appeared, Mr. Tripathi?
No, he's in the next one, 30th. 30th.
Item 27.
This is 27.
Sorry, I'm sorry.
Item 30, Mr. Tripathi is,
Okay.
was just asking for a copy.
All right.
We'll give him a
All
copy.
right.
All right.
Okay.
Wait.
Thank you.
And that will happen. Yes. 1 week, 6 weeks.
Item 28.
28, my lord, there is a delay of 173 days. Issue with respect to an ID case, the order of termination was passed and there was a direction for reinstatement of the petitioner. And but so far as the back wages is concerned, the ID court made it, the ID tribunal made it clear that he will not be entitled for the back wages. Then that order was challenged both by the state as well as by the person concerned, by the respondent. State writ petition dismissed. Writ filed by the respondent allowed to the extent that he will only be entitled to the consequential service benefit upon reinstatement. But so far as the back wages is concerned, that part of the order was affirmed. So he will not be entitled for the back wages. Then after 8 years, again he made a representation to the authorities, approached this honorable court, then gets an order that the representation be considered. Authorities rejected it, that you have already received the consequential service benefit. Upon reinstatement, however, you are not entitled for the back wages. That rejection was again challenged in the writ. And the honorable single judge has come to a finding that
So notice.
Item number 29.
29, here there is a delay of 115 days related to that Malayananda city.
So what are we doing in that case?
Will notice will be disposed of in terms of that Bindusagar. You have a point.
And, Lordship will dispose of that.
No, but that is what is this?
Here, my lord, the death occurred in 2017.
My forgetfulness is my virtue. So I forget things. I don't remember what order has been passed.
Death occurred in 2017. Application made immediately, but the application was not in the format. Then subsequently, application made.
No. In such matters, we have disposed of the cases in terms of Bindusagar or what?
Yes, my lord.
All right. Do you have a copy?
So this is the similar nature.
Yes, madam. The order is there also. The final order passed that you consider in terms of Bindusagar, Satyavrata Tiwari, and yes.
Yes.
Item number 30.
But no prejudice will be caused to the. I also remember that order. Not anything order.
Where limitation is there, your lordship normally issues notice. Where limitation is there in such type of cases, normally your lordship issues notice. Thereafter, after their appearance, your lordship passes that order. But no way he is affected by.
No,
by
are you hearing?
Not in this.
Like 29.
Item 30.
Item 30 minutes. In this case, I have appeared to caveat minutes. Let a copy of the writ appeal may be submitted.
Let a copy of the writ appeal be served upon learned counsel. Mr.
Atul Tripathi, my lord.
Mr. Atul Tripathi, who has appeared for the opposite party.
Sole opponent.
Sole opponent. Stop. By filing caveat. Stop. When do you want?
3 weeks after.
You don't want a copy of the IA?
Yes, my lord.
You want?
Yes,
Appeal
along with the copy.
I'll give him along with the copy of the IA.
and the application seeking condonation of delay.
Little earlier, the filed contempt, 2 weeks.
I undertake not to pursue contempt matters.
So in counsel for the respondent has very clearly submitted that he shall not pursue the contempt matter in the case.
Wait.
This should be the approach.
Yes, my lord. Grateful.
Item 31.
that 264 days delay, my long friend is saying that a similar matter has been dismissed. You'll also call this matter tomorrow, I will verify.
Tomorrow.
Tomorrow, I'll verify it.
As request of the
Verify for me.
Item 32.
Maybe. This is a matter regarding recruitment to the post of junior engineer civil.
Yes, sir. What is the delay?
Delay is 18 days, minutes.
18 days. You are for the other side.
I am for respondent number 1, my lord.
We are condoning the delay.
Yes, my lord. No objection.
We have heard learned counsel for the appellant and learned counsel representing the sole respondent or how many respondents?
So, state is also there. State is also there. Respondent number 2.
I am for respondent number 1.
Testing
Appeared or will appear?
Already appeared.
He has appeared. Your file was Kalatama.
Yes, my lord.
Stop. Considering the permissions in the bar, the delay, so and so is control, I am so and so is control. Does this appeal for admission?
Sir, my lord, similar matter, my lord, common judgment challenge, analogous hearing.
No, you want it to be listed along with another matter.
Yes, my lord.
What is the number?
Number, my lord, double PC number 1728 by 2024, 1851 by 2024, 1294 by 2024.
Yes.
Out of a common judgment, 7 writ applications are disposed by a common judgment. 7 writ applications has been filed. And one of the matter has been listed. Same thing, same fact is same.
Whether these matters have been listed or not, WS 170.
These are not yet been listed.
Oh, then not now, Mr. Counsel, later. Those matters have been taken up. Those matters have not been.
No, not listed. Copy of the writ of
Copy of the writ appeal, let a copy of the writ appeal be served upon learned counsel for the respondents in course of the day
list in matter, my
by tomorrow.
matter to list into matter, my next week, my lord.
No, it will come after 4 weeks.
Item 33.
They have filed a contempt application saying that the order of the single judge has not been complied with. This may early date may be fixed or let them may not press the contempt application. They are pressing that.
Where?
Before this one, before they have filed contempt application.
Contempt application.
Single judge.
Yes, they are pressing that contempt application.
Let us see. Not now.
Item note 33.
A copy of the writ appeal I am submitting right now. Have you indicated something?
Copy of the writ appeal has been served upon learned counsel for the respondent in court.
Yeah, Mr. Mahapatra. Are you Mr. Mahapatra?
No, my lord, Dilip Mahapatra. I am from Balaram
Associate
Behra.
to Mr. Mahapatra.
Balaram Behra.
Yes, my lord.
Item 33.
Your lordship, we would like to withdraw the petition.
Item number 34.
May I please, your lords. So, Lord, this is application for amendment of the writ petition. Here is a case, my lord, pursuant to tender process, petitioner qualified in the technical bid. There is a condition that if the bidder quoted, my lord, more than the 15% excess, then bid will be rejected and it will be below 14.99, it will be selected. 14.99 petitioner, my lord, price was open, petitioner declared a first lowest, my lord. Lord, thereafter, without any transparency procedure, they have cancelled now the invited tender, my lord, 5 crore excess than the rate lowest amount of the petitioner, my lord. This is public money, my lord, 5 crores, my lord, the last petition is.
No, don't get worried about public money. That is.
Your lordship, there is, your lordship, that 14.99, so this amendment was filed challenging the subsequent tender, which has been invited higher rate, my lord.
But see, in the tender process in which you had participated,
Your lordship.
that has been cancelled.
Your lordship.
So that writ application has become
No, my lord, I am challenging the cancellation, my lord.
Cancellation you are challenging by way of amendment.
No, I am your lordship, cancellation already.
Work is exactly the same.
Exactly same, your lordship, I'm
But another, they know the work. If it is too low, it is not, may not be possible to complete.
No, no, my
the
lord,
work.
the
That
condition
will be-
provides 14.99. If we are on the terms of tender condition, my lord. Now, your lordship, that cancellation always a hurdles of the writ jurisdiction. Now, my lord, Subodh Singh's case, my lord, now as a Calcutta Chief Executive Officer case, the cancellation were quashed, retender quashed by the Supreme Court, apart from this honorable court. And the honorable Supreme Court held that transparency and public interest to be met, Subodh Singh case, my lord. And here is a case, my lord, you know that I have agreed for 14.995 crores less, and knowing after price bid, you open, my lord. You cancel, my lord, and then you invited, my lord, 5 crores excess from the my rate.
So what do you want to amend?
My lord, my amend to addition to amend the prayer in adding the challenge the subsequent tenders, my lord.
So where is that?
My lord, the IA number, my lord,
No,
90
here number,
9065.
this application has been filed seeking amendment in the writ petition in view of developments or development subsequent to filing of the writ petition. So stop. The petitioner has challenged in the writ petition an order dated 23/2024, whereby the tender for the work for construction of Bolangir bypass road from 1/500 kilometer to 6/100 kilometer, 8/300 kilometer, 8/800 kilometer, and 10/200 kilometer to 11/910 kilometer in the district of Bolangir under a state plan and court was cancelled. So it is the petitioner's case that in the said tender process, the petitioner had participated and was adjudged L1. So it is further case of the petitioner that subsequent to passing of the subsequent to cancellation of the tender notice, the opposite parties have come out with press tender.
Yes, lords, fresh notice. Fresh tender for
Where is
self-same
that?
work. Serial number 3 at page 11, my lord.
State.
35.
Press tender wide feed identification number CEDPI and R-01/2024-25. So considering the nature of challenge made in the main application, the application seeking amendment in the writ petition is allowed. So stop accordingly, this application stands allowed. The amendments made in the present application shall be treated to be part of the main writ application, part of the pleadings in the writ petition. So stop. That's all. The petitioner is thus permitted, allowed to question the correctness of the correctness of issuance of subsequent advertisement dated 9/7/2024.
9/7 is the corrigendum, that is 24/6/2000 original order that was subsequently changed.
24/6/2024. Yes.
Obliged.
Item number 35.
Yes.
May I please allow? No, sir. This writ application is filed challenging the award passed by the learned Labor Court ex parte award the background of the case is that the opposite party number 2 was admittedly daily wager He worked in that establishment from 1994 till 2001 And in petition. In 2000, a policy decision was floated by the state government stating that due to financial stringency, excess force should be not required, and persons last in first out has to be adopted, and persons were to be terminated from or disengaged from service. In the process, the opposite party number 2 was disengaged from service. He challenged that before the Labor Court, saying that it is violative of principle of natural justice. So also the provisions of the ID Act has not been followed, and similarly situated persons junior to me have been engaged in the continuing the service. Even though a reply was filed by the petitioner, but during the proceeding they remained ex parte. No evidence was laid. Accordingly, the Labor Court passed an ex parte award, stating therein that he has to be reinstated and be given all full back wages. Our case is that one thing, it's an ex parte award, but at the same time, here the petitioner, the OP number 1 was the one workman, but in a similar case, that is 50 of 2002, more than one person challenge this notification of the state government, so also the retrenchment, and therein the same Labor Court had dismissed the claim, saying that all the provisions of the ID Act has been followed. So there are two contradictory decisions from the same forum. That's why we have challenged this in the writ application.
No, but in those cases, evidence must have been laid.
Exactly. Here only case is that
the evidence which were laid in those cases could not have been relied on by the tribunal in the present case.
No, they cannot be, because it has to be specifically laid in this case also. Here we have explained why the evidence could not be laid, because we have taken a ground that the person who was in charge of this, he suddenly died. So the dates and everything could not be known to them. So accordingly, even though opportunity was given, no evidence was laid. Accordingly, the ex parte award has been passed. And if you also, because in an ex parte award, and till now we have been complying section 17B, people also can remand the matter to the learned court below, giving an opportunity to place the materials on record. With some compensation, also can do that also, because he has been sufficiently protected by lordship by award under section payment under section 17B of the ID Act.
Lordship, this is not an ex parte judgment, first of all. And your juniors to them are continuing. I've also given an affidavit to that, your Lordship. And your Lordship, they have stated that some official staff had passed away, because of which they could not they could not give the evidences, your Lordship. Paragraph 6, your Lordship. It was because the case record was sudden with the senior clerk. He suddenly passed away in 2009, your Lordship. The judgment is of 2011, your Lordship. And so, of course, this ground is completely a lay ground to be relied on, that because of a single staff who has passed away, the entire case cannot be taken up because of it. And the learned Labor Court Lordship may permit me to read out the findings, Your Lordship. At page 28 of the writ application. The workman witness 1 in his affidavit evidence has stated that he was working under the management as chainman since 1994 until the date of his termination without any break. He further stated that some juniors to the workmen are still working under the management. At the time of termination of his service, the management has not followed the provisions of Section 25F and 25G of the ID Act. Though the management has taken the plea in the written statement that as per the orders of the government and with due compliance of the provision of the Industrial Dispute Act, the workman was terminated from his service, but the said stand has not been substantiated by the management in any manner by adducing any rebuttal evidence and providing any documentary evidence, except the above plea that the management has not disputed anything regarding the plea of the workman. Therefore, the evidence adduced by the workman remains unchallenged. On perusal of the documents as available in the case record, it is clearly shows that the workman has worked under the management for more than 240 days in 12 calendar months preceding to the date of termination. And at the time of termination, management has not followed the provisions under Section 25F of the Industrial Dispute Act, which is a mandatory provision 1. So on careful consideration of all the materials available in the case records as discussed above, and in view of the unchallenged testimony of the workman, I came to the finding that the termination of service of the workman with effect from 1/12/2001 by the management is illegal and unjustified. So he's entitled to reinstatement with full back wages. Here the workman was terminated from service because of a faulty gradation list, Your Lordship. And juniors to him are still continuing.
So how do you say that it is an ex parte order? It is not.
Paragraph, page 20, paragraph 6.
That we have seen.
Specifically states.
Says that you could not substantiate your.
The ex parte means we filed a written statement, contributing all the statements made in the claim, but we did not participate in the proceeding. So that is an ex parte order, even though, of course, opportunity was given, but we did not deduce an evidence. That is the statement, but subsequently remained absent and did not take part in the hearing through sufficient opportunities were given to him. Admittedly, because of the fact that the person who was in charge of the case, he could not, he died and records.
He died in 2009.
Yes, the award of see, the evidence was recorded during that time only, The evidence was recorded 2009-10, So his evidence was recorded. When we are given the opportunity, we did not have it.
And then in 2011, the order was passed.
Yes.
You filed the writ petition in 2013.
Yeah, 2013.
Why should
and I've given the annexures also, Lordship may kindly look at. Annexure, they've been section. The finding of the London Court below is that Section 25F and G has not been complied with. I filed a document to show that 1 month notice was given. He was given 1 month's salary. So also gratuity was also paid. He has received those. I filed the documents before Lordships. Not that 25 provisions of 25 not been complied with. That has been complied with.
He has received that on a very belated stage, Your Lordship. He has received them with objection at a very belated stage, Your Lordship.
You are required to pay that amount.
Oh no, before it was not.
That if you also see here, no counter affidavit has been filed, contributing all the averments in the writ petition. That belated, what my friend is saying, if you also look at the dates also, no counter has been filed.
I have, Lordship, on the instructions of this court, on directions of this court, I have filed one on 22/4/2024, wherein I have only mentioned that juniors to him are continuing.
But 22/4/2024, an affidavit has been filed stating that some of the juniors to him are working. That is the affidavit only. No.
File your affidavit.
Counter affidavit has been filed.
Your Lordship was actually, felt it was not necessary. So I
Because this is a very clear-cut case wherein juniors to him are continuing and the
See, if
mandatory
any order
provision.
is challenged in a writ proceeding on the basis of any fact, then the other side has a duty either to accept that or controvert.
I bowed down.
So it is not that this order
Rely on my counter affidavit on 22/4/2024.
that affidavit does not deal with that. So government.
Here I have mentioned that he was retrenched because of a faulty gradation list. I have not made any specific denials, of course, but I have also annexed the juniors.
He is making out a clear case that the requirement of section 25F was compliant with. You are disputing that, so your oral submission will not do.
First of all, the juniors to him are continuing, and
Junior, that is not.
so when juniors to him, even
Sometimes
if
we are not satisfied for two reasons.
No.
One, that the fellow died in 2009.
No.
See, right in a submission that on the ground of death, you cannot take a plea that the functioning of the department.
Right, no, that is true.
And secondly, your challenge to the order, to the award, after 2 years.
No.
In the present set of facts cannot be.
And one more thing, admittedly, not the court invoked your lawsuit judgment and Supreme Court judgment. He may direct for reinstatement, but he cannot direct for payment of full back wages.
of course he can.
That is also one of the grounds I have taken in my writ application.
Full back wages that we can take care of. Full back wages.
And similar facts, more than 20% those who have challenged the same termination in ID case number 50 of 2002, their claim has been rejected.
No, Your Lordship, that is a totally a different case.
No, I have given the annex or
No, Your
says, I will find out the same notification.
May I submit, Your Lordship?
Allow him to argue, then.
If you also look at that is the annexer, the same notification of the state government that 30th 12/2011, wherein these persons were declared to be surplus and their services were dispensed with.
The question is same.
Yes, Lord, because we never brought that to the notice of the learned tribunal.
So therefore.
Yes, Lord, that I understand.
May I submit?
Pass the order and thereafter.
That is true. We have never brought it to the notice of the labor court saying that similar matter has been disallowed, but that was never brought to the notice of the court by us. Neither the evidence was laid, nor this was brought to the notice of the learned court below. These are the facts, Lord. You can consider.
Earlier, this question was also raised, Your Lordship, and the state had taken specific instruction that after that only they came to a conclusion that this case is not similar to that of it. They have taken 8 adjournments to take the specific instructions. And this person was not even a party to it. And
Party to what?
to that case, that particular case,
Yes,
my Lord,
how can he be party to that?
he is not a party to it, and that was not a case that is similar to that of the petitioner. They have taken instructions on it earlier also. They have taken instructions on the same matter
I have
earlier
taken
also.
instruction on the same that this petition, this opposite party number 2 was not a party to that other proceeding. But the proceedings are same, but he was not a party.
Proceedings are not same.
How can he be party to?
Yes,
another proceeding?
that instruction Lordship earlier was directed, I was directed to take instruction whether he was party to, because there were group of employees. And here he was one. So I filed an affidavit saying that no, he was not a party to that. So it can be independently not dealt with. Lordship may take care of that, because no vacuages. I've got also judgment of Lordship. The last 2 cases have also held that full vacuages is not entitled to. And I've also got a judgment of the Supreme Court that BSNL matter, where Honorable Court has stated that full vacuages at the time of reinstatement is not justified in of course. in cases of, depending upon the nature of the case, my lord.
Herein, your lordship, it is because of the fault of the management this workman has been suffering for this long time, your lordship. The workman is not at fault in any way.
Because of the fault of the government,
Officials.
you are gaining.
Lordship, I'm suffering.
You should be happy
I'm-
that the person died and
no, your
the
lordship.
matter could not be prosecuted by them.
Even if he was alive, your lordship, when they have not complied the mandatory provisions, your lordship.
And interestingly, they had also
And
challenged
also-
the notification before the tribunal. Tribunal had never interfered in that.
Alright.
And in many other cases also, these persons have been reinstated back with
For orders.
Item number 36.
Was in item number 36, lordship had directed me to take instruction by the order dated 86/2024 regarding the notification. But today I have received a letter, my lord, because the case, my lord, relates to the year 1984. The order passed on in the 1984 is under challenge before lordships. So records they are trying to find out. If lordship see the that is why my lord, CS sought for 2 weeks time. The collector is requested to make a mention because 84 records they are trying to find out, my lord. So only 2 weeks time lordship may grant so that I can produce those before lordship.
Weeks after, but get the notification of the government.
Notification, even they are not getting lordship.
It's a notification of the government.
The thing is that these are very old matters.
The old matters.
Old matter.
But you also specifically wanted the minutes to.
And we intend to take up old matters. We are going to give priority to the old matters because they are pending and we are taking up various matters only.
Let's say fix it to 7th or 8th schedule.
That's a very simple thing, Mr.
No. Only you also wanted to that order, the notification of whether this office sub-divisional officer Southern Kotak was authorized by that notification. In fact, if it's not available in the collector office, he has not tried to get it from the Board of Revenue also. He could not get. That is why he said that some more time they will find it out from the state.
And if he does not find, then after 2 weeks, we'll keep on searching.
That is also not the point.
And if it is not there, then
It must be there in the archives at least. We have a government gazette notification has to be there in the state archives.
always as requested on behalf of the state, requested by Mr. Samantral, AGA for the state. 2 weeks further time is allowed to comply with the court's order dated 18/6/2024.
Yes, 18/6.
Item number 38.
Along with the connected matter, right?
The interim order is there, but
Interim order shall continue.
सात ना आठ देखो ना चिट्ठी पठेई
Your blood is question is whether the other side's husband was continuing a partner in a dealership. The present petitioner was selected for dealership in BPCL. But while the process was going on, it was found that her husband is continuing as a partner in a oil pump owned by IOCL. So there is a restriction. If any of his relations are continuing as partners, he will not be selected. And his selection was rejected. Ultimately, she filed a writ and she was allowed. I filed a writ appeal. A writ appeal was allowed in stay has been granted. I have filed a petition. Your Lordship may kindly see. There I have given a document where the IOCL has provided it, which shows that her husband continues as a partner. The whole point is that. Who is appearing for the other side?
Well, I am.
The annexure 5 minutes is the document. If your Lordship will kindly see, he says, I have resigned, but the flag Y, I think. It is flag Y.
Flag Y.
Yes.
What is that flag Y? Flag Y. But this document you are bringing on record in the writ appeal.
Yeah. No, I had in the writ application, I had avoided that. On the basis of information provided. On the basis of information provided by IOCL that he continues as a partner, but that was rejected. My contention was rejected.
Affidavit.
Additional affidavit, flag Y.
Well, this is very bad practice. Advocate's clerk is swearing the affidavit.
Identify that. This affidavit is shown by an officer.
Paragraph 1. Please come to paragraph 1.
No, I have filed an affidavit.
No. Please come to paragraph 1 of this flag Y.
No, that petition merits additional affidavit on behalf of the appellants, Sri Ankur Kumar Mishra.
Suresh Chandra Sundra.
That in the writ appeal I have filed that document.
The writ appeal, how can you file this? Now this is shown by the advocate's clerk. And he is looking after the case.
No, I have filed a corrected one. I have filed a corrected one. Advocate's clerk must have identified. I have filed a corrected one. That is the document. Let's say I keep it to tomorrow. I will pop.
The first affidavit they had filed, which was the advocate clerk had filed that affidavit. Thereafter, they filed another affidavit.
Bringing on record, stating the same facts.
Same fact.
That is a flag Z.
Yes, I have also filed an objection to that.
Objection to what?
This affidavit that at the appellate stage, he cannot bring on documents which are not before the Malad single judge.
Before the Honorable Single Judge, I had categorically stated that I have obtained, as per the instruction of the IOCL, her husband continues as a partner of the other company, other petroleum outlet. But our contention was rejected and writ appeal was allowed. So thereafter, I have filed this document after obtaining from IOCL.
Oh, then you could have filed a review application. The document was not there before the learned single judge.
No, the document was not there, assertion was there.
Assertion is not enough.
Yes, no, sir, that may be a mistake. I was not at that stage. That is my mistake. I understand that.
You can seek a review. You can seek a review if you want.
Yes.
Selling the order passed by the learned single judge in the present intra-court appeal. The senior counsel appearing on behalf of the appellant has submitted that the respondent's husband
Yes, no husband.
was
a partner of.
Before that, may I
Just a
interrupt, my
minute,
lord?
just a- No, partner
Yes, my lord, she was a partner.
of.
Ma Santoshi filling station.
That part has been dealt by the single judge. You also may kindly have a glance. That part has been dealt by the single judge, how he has disbelieved that he has resigned and how that another writ application was filed by the erstwhile partner of that company, that firm. That has been dealt by the single judge. You also may kindly have a glance. Thereafter, you also may pass on.
Paragraph which?
But I am reading that. That paragraph 4 of that judgment, my lord. May I read that, madam? Notice advertising inviting application was issued by the opposite party oil company on 19th October 2014. The petitioner husband had sought to resign from being a partner in running RO in 7 July 2010. It appears from the impugned communication that IOCL terminated the dealership on 31st January 2011. That is more than 5 months after the petitioner's husband has tendered resignation. The husband made an interim application in IA number such and such in the writ application filed by the petitioner, a partner. The applicant said internally as follows. The what interim application was also admittedly for violation of the terms and condition of the keeping in view the marketing display guideline of the oil company, the dealership license stood terminated on 31/1/2011. That the admittedly writ petitioner has been challenged terminating the order in the writ petition application without impleading the present petition as a party. The writ petitioner was not authorized by the petitioner to file this writ appeal. The writ petitioner is liable to procedure the authorization letter, if any. And the fact and circumstance of the present petitioner as an outgoing partner is a necessary party in the proceeding or has nexus in the issue that has arise for consideration in this writ petition application. Therefore, he should be implemented as a party. Thereafter, my lord, no further proof is necessary to establish the fact that last paragraph, my lord, that in the said writ petition, petitioners were the other partner and the partnership firm itself known as a Ma Santoshi filling station. As the aforesaid order dated 16th November 2019, the writ petition, the other partner was disposed of. It will be noticed from the above extract of the said order that the division bench found that the petitioners continuing and enjoying the contract for 15 years, petitioner can only mean the partners. They are herein the petitioner's husband and the firm. The husband also aforesaid as was added as a party on 31st August 2019. This fact, coupled with the husband's clean contention that reason for wanting to have been added as a party in the writ petition, makes it clear that his partner had accepted the resignation, thereafter proceeded to run the RO on his own. Furthermore, the disposal of the writ petition, vacating the interim order, restored the order of termination dated 31st January 2011. As a consequence, the said dealership is stood terminated long before the notice and the petitioner application in response. As such, there can be no confusion thereafter on interpretation regarding whether or not the family unit of the petitioner was involved in the running of the RO. The writ petition succeeds, the impugned communication is allowed, madam.
If your lordship will kindly see
Just
that.
a minute, So according to you, your husband was not continuing as partner
My lord.
when the LOI was
Issued,
granted
my
in
lord.
your.
My lord.
Right.
My lord.
Where is that resignation?
That is, my lord, that has been noted, my lord, in paragraph 4.
Forget the order. What is there? Where is the proof that your husband had resigned?
I had filed, my husband has filed in that writ application.
How your husband was not a party, could not have been a party to that proceeding?
No, there are two litigations. May I clarify, my lord?
There were two writ petitions.
Intervene. He wanted a recall of the order, husband.
The other partner of the my lord,
Had challenged the termination.
challenge termination.
So-
Another writ application was filed.
Yes. So this one's husband filed intervention or what?
Yes, intervention filed, and there, my lord, he filed the resignation letter, everything, my lord, and that writ application was dismissed,
If your lordship
which has been taken note of in this writ
Let us
application,
understand the fact first. Please wait for a while.
my lord.
You had applied for this.
My lord, I have applied for this, my lord, the dealership,
Yes.
I was allowed, LOA is issued, and thereafter, the partner of my husband gave a complaint to the company, so my LOA is kept in abeyance. Then, my lord, I came to this honorable court. This honorable court disposed of with a direction that you file a repentation. Let them consider that because your husband already resigned. That is to be taken care by the company. I approached the company, my lord. The company rejected my repentation, my lord. Keeping the kept in abeyance, affirm, my lord. Thereafter, I challenge and filing this writ application, where, my lord, this writ application was allowed, and he raised a question, my lord, that the husband was a erstwhile partner in that company which has already expired and which was stayed by this honorable court.
Expired means what? Company expired or?
His dealership expired. In the epochs of time, his dealership has expired, my lord.
When? On the date when you were participating or after that?
No. When the case was disposed of by this honorable court,
Disposal of the case is not important.
my lord.
The date when you had
Applied.
participated, you had applied, that date is crucial.
Yes,
So
that
whether on
day, my lord, I had resigned.
Whether on that day that company was there or not, that
Yes.
the other dealership was there or not.
No, that was terminated, and that was running.
Alright, terminated when?
31st January 2011,
2011.
my lord.
And when this process had begun?
2014, my lord. This process began in 2014, my lord.
And the other dealership was?
The other dealership, my lord, after my resignation, my lord, my husband's resignation, my lord, in that firm, the other partner, he filed challenge the termination and filed writ application, and admitting therein that I am not a partner, and he had added another partner who is also party to that writ application. If lordship will be clear,
So
the lordship call for that record.
Record is here.
The record
Is Soumya Ranjan Meg.
my lord. If lordship sees that record, it will clear from that record that he has accepted my resignation and he has added another party as Sonu Agrawal as a party to that RO, and both of them had jointly filed that writ application, and he has also filed an application for intervention.
So counsel,
My lord.
that dealership, according to you, had terminated on 31/1/2011.
My lord.
Much before this process had
My-
begun in 2014.
My lord obliged. My lord.
And therefore, according to you,
My lord.
even if your husband was partner and had not resigned, so that could not be a ground for disqualification. Is this your submission?
No, my lord. My submission is my partner has already resigned. My partner had nothing to do with that dealership.
Your father,
And
not your partner.
my husband, man, sorry,
Okay,
I'm excuse my husband. The petitioner's husband was not a partner. He has resigned long before the termination of the firm.
Exactly,
When?
that was what was.
Resigned, resignation. 7th January, 7th, my lord. That is in the judgment. It has been
7th January what?
the 7th, my lord, 7th July 2010,
2010.
my lord,
So 7th July 2010, when he had resigned,
my lord,
and the dealership itself had terminated on 31/1/2011.
my lord.
Then where is the question of disqualification in a process which was initiated in 2014?
That is exactly, my lord. That is why, my lord, I have come before your lordship, my lord.
But what is the importance of your resignation? The dealership had was terminated in 2011 itself.
No, their case is, since the dealership, the other man who challenged that, since that order was stayed, you continued to be a
Why are you
partner.
shouting?
My lord?
Can you?
No, I'm sorry, my lord, my voice is like that. Their case is, my lord, since the termination was challenged before this honorable court, and that was stayed by this honorable court, so by that process, you become a partner on that company. That is also their stand in this writ
I
appeal.
have filed a document.
That is also their stand in this writ appeal, my lord.
All right, please take your seat. Let us see.
If your lordship
Yes.
will kindly see that my specific stand on the basis of a information received from the IOCL that he continues as a partner as per their records.
He
Maybe.
may have continued as partner.
Yes.
But that dealership had come to an end on 31/1/2011.
But I think that dealership is continuing pursuant to a court's order.
Pursuant to a court's order.
Is it
Filed by
that
another party.
our company is continuing?
Filed by another party.
No,
Then?
but both.
File
You
by
know, keep it to tomorrow, I'll get the.
All it tomorrow.
I'll get that information from the oil company itself.
As requested on behalf of the
But not tomorrow, day after.
day after.
No, 39.
Hmm.
39.
May I please allow?
Yes.
The Annex 3, Your Lordship, page 69, the order of single judge is under challenge, Your Lordship, where the writ application of the present appellant was dismissed. The issue, the fact remains, Your Lordship, page 34, one advertisement issued for appointment of assistant PP, assistant public prosecutor, Your Lordship, by the Orissa Public Service Commission, Your Lordship, OP2.
Then
Your Lordship could find from page 34 the advertisement. Vacancy position was grand total 46, and out of that, Your Lordship, out of total 46 number of posts, as means
36.
46, Your Lordship.
46.
Total 46,
Ah.
18 women. Out of that, Your Lordship, out of total 46 number of posts, as mentioned above, 4 posts are reserved for persons with disability.
Yes.
And out of that 4 person post for disability, low visions 2 and locomotor disability, including leprosy or
Low vision
acid
2
attack 2,
Low vision 2
and a locomotor 2, also locomotor disability 2. And the present appellant belongs to locomotor disability, and I apply for the post. Selected in the written test, the call for viva, but in final merit list, Your Lordship,
Yeah.
he has not been placed, and page 54 is the final merit list.
Yeah. Yes.
Where, so for the locomotor disability concern, Your Lordship, only 1 post has been filled up, and another 2 posts was there. Another post was not filled up from the locomotor disability, and all 46 posts has been filled up.
All
So-
46 have been filled up.
Yes, Your Lordship, page 55. All 46 filled up, and 1 locomotor disability post filled up, and another locomotor disability they have not filled. Challenging that merit list, though I have been called for viva and secure sufficient mark as per the mark they have taken into consideration. Challenging that, I have filed the writ application, and OP appear filed their counter affidavit. And considering the fact and without considering my contention so far, the decision of the Honorable Apex Court, Your Lordship, passed in Mohish Gupta and others versus Jaswant Kumar, Oivar and others, reported in 2007-8 SCC 621. The Honorable Single Judge, without considering the ratio decided in that judgment, Your Lordship, dismissed my writ application. The
ratio decided in that case, Your Lordship, that is also quoted in the judgment, Your Lordship, impugned judgment, page 77, para 12 of that judgment. Disability has drawn the attention of worldwide community. India is a signatory to various international treaties and conventions. The state, therefore, took a policy decision to have horizontal reservation with a view to fulfill its constitutional objects as also its commitments to the international community. A disabled is a disabled. The question of making any further reservation on the basis of caste, creed, or religion originally may not arise. They constitute a special class. The advertisement, however, fails to mention, this is the finding of the Honorable Supreme Court, the disabled is a disabled LRC. So the observation, the finding given by the Honorable Single Judge, that though in the advertisement there is no male, no reservation for male SC candidate, then he is not entitled to get.
See, it is like this,
My lord.
that if there are 10 posts advertised, or see 100 posts are advertised,
My lord.
and 2 posts are reserved for disabled candidates,
My lord.
irrespective of the categories, 2 posts are to be filled up. Women, male, or say SC, ST, general,
My lord.
whatever. It is not that for general one and for SC1 and for ST1, this is what you are submitting. And this is the law.
My lord.
This is the law, that if that these 2 posts are filled up, irrespective of the category.
My lord.
So what is wrong with the, is this your case, that no disabled person in any of the categories like male or female was found other than you?
Yes, Your Lordship. 2 locomotor posts were reserved for locomotor reserve 2, but only 1 has been given. That is the case, Your Lordship, my case.
Try to understand this.
My lord.
This is the difference between general reservation and horizontal reservation.
My lord.
All right. General reservation means the vertical reservation would mean that those posts are to be filled up only by those those 2
Categories.
posts are separately for those candidates. But if those many of number of persons are already available, then no further reservation is required for them.
Are you saying that 1 post was not filled up?
No,
There were 2 posts.
as per advertisement, there is 2 posts for locomotor disability.
Yes.
But in final selection list, only 1 post for locomotor disability has been filled up.
What happened to the other post?
There is nothing else.
Is this your case? Is this your case that no other person having locomotor disability was selected in the for the post?
Yes, that is my case, Lordship.
Where is that? Where is your statement?
Lordship, kindly have a glance on the final merit list, Lordship. That is at page 54. Only serial. Page 55, serial number 40, Lordship.
Page?
Page 55, Lordship.
This has to. If you have the writ
Serial-
petition.
No, my Lordship, writ appeal.
Yes, 55,
My Lordship, serial number 40.
40.
One Harihar Maharana, only that person has been selected as last column, Lordship, unreserved locomotor disability, LD. And the super low vision 2 have been accordingly filled up, and only 1 LD has been filled up. but advertisement vacancy was reservation for 2 only.
So suppose they don't find somebody who qualifies, then they won't fill up. Is it your case that that which was for that orthopedically handicapped, somebody somebody else has been selected, some other like visually handicapped or visually
No,
impaired?
that
It is
is
not
not
been filled up.
No, the case of the respondents, Your Lordship,
Yes.
they stated that though there is in the advertisement, there is no male SC reservation is there. So you are belongs to male SC category, so you are not entitled to get that, which is that is their
Where is the
submission.
advertisement?
Advertisement is at page 34, Your Lordship.
(34) is the advertisement. Persons with disabilities belonging to SC are eligible for age relaxation. All right.
May I assist your lordships for the commission?
Please.
If your lordship. Madam. Madam.
Yes.
Kindly look at the advertisement, page 34.
Yes.
My lord,
Page?
page 34, running page 34 of that written. Lordship, first keep in mind that this advertisement is not under challenge. And he has participated in the recruitment.
Internal page 6 or what?
Page 34.
Internal page, no page is visible. So
Advertisement.
34. Running page 34.
30,
68.
34.
ऊपर में 57 से
57. All right.
So
Yes.
34 will
34.
be
Yes.
50.
Lordship got it?
34. Yes.
Yes. Lordship, kindly see para 2, vacancy position.
Yes.
They have categorized.
Yes.
On reserve 41, 14 women. Scheduled caste SC 4. And the total 4 is for women. Well, he has applied as a scheduled caste candidate, male category. So there is no reserve post in the vertical consideration for a reserve male category candidate, because total is reserved for. The lordship knows it is a cadre base. Total strength on that basis, government has made the requisition. Accordingly, the advertisement has been made. Then lordship, kindly see the paragraph. Out of total of 46 numbers posts as mentioned above, 4 posts are reserved for persons with disability whose permanent disability is 40% and more. 4 posts are reserved for ex-service and so on. Need not be read further. Here, your lordship will in column 3. My lord, total disability is 4, low vision 2, locomotor 2. So now, out of the candidates, first we have to take the reservation in vertical line, as your lordship rightly pointed out. In the vertical, unless somebody comes within that category, then reservation does not come in a horizontal consideration. So in horizontal consideration, your lordship will find page 55, the selection list. In the selection list, he is claiming that I am a scheduled caste. First of all, in vertical, there is no reservation for scheduled caste, male candidate. So from the female, we got only woman candidate, locomotor 1, locomotor disability. So accordingly, in consideration of horizontal reservation.
So your case is that 4 posts were reserved for scheduled caste women.
Women.
No post was reserved for scheduled caste male.
Yes. Yes.
All right.
Yes.
Therefore, he could not take the benefit of reservation of scheduled caste.
Scheduled caste.
Being a male candidate.
Male candidate.
This is your case.
Male. And that is also the findings lordship will find. That was my contention
So
also.
his candidature was to be considered against what?
That's the against only for the scheduled caste, had he come in the merit, then you could have occupied.
Or if he does not qualify for any of the reserved category posts,
Yes.
then he should be considered for against what? It's very simple, against the general merit.
In a general merit.
All right.
Yes.
So general merit, his case was required to be considered.
But in the general merit, he has not come.
No, not required. So if in the general merit, the two posts were required to be filled up.
Yes.
So if he had the disability, and if he was otherwise qualified, then he could have appointed, he could have selected against one of the unreserved posts. At least 27. This is the principle of horizontal reservation. Provided it is not, see, according to your submission is to be accepted, then no SC candidate, SC male candidate would have applied against this advertisement. Is this your submission?
No, SC candidates would have applied.
Would have applied?
Would have applied. And he has applied for a SC candidates.
Yes.
He applied.
Yes, right.
Yes.
So he claimed to be an SC. You could have rejected his claim that no, you can be considered only against unreserved posts.
Well, let's kindly see the findings. Let's kindly see the findings.
Finding?
What are our contention? My lord, what your lordship says, that may be also subject to scrutiny, because unless he comes in the general
My lord says is subject to scrutiny. All right, you scrutinize that and you come back. This is the question involved.
That is right.
This is the question involved that if, as per the advertisement, two posts were to be filled up from amongst the candidates belonging to having locomotor. Okay. He was SC male, and there was no reservation for SC male. Okay, but his case was required to be considered against unreserved general. How could you take a decision that since he is not?
But only yes, only something strikes to my mind.
Yes.
Provided he also comes in the merit list of the general category.
Oh, if he comes in the general merit list, then he is automatically selected. But if he does not come in the merit list, and if there is a candidate having disability, then he will have to be shifted there. This is the process of horizontal reservation. Someone will have to be removed from there and he will have to be shifted. This is the process.
You have considered him only against SC?
Because he had applied for SC.
You could have rejected his application. There is no provision.
No.
Examine it. It's an issue. It requires consideration.
But lordship,
We are giving you time.
let me, that is right. But lordship, for your lordship's clarification that
All four were
findings basing on the decision of the Supreme Court as well as also of the.
Please examine all the principles of horizontal reservation and then examine how the case of the petitioner was required to be considered. We are giving you enough time.
All right.
Whenever you want.
May I please, your lordship? I am for OP number 47, lordship. Lordship, may kindly peruse page number 34. Here there is a category and a subcategory. The subcategory derives from the categories. Here clearly the advertisement mentions candidates belonging to PWD category ex-servicemen posts shall be adjusted against the categories which they belong to. The categories are in the above table. That is table number 1, vacancy position. Point number 2.
He did not belong to any of the reserve categories
Lordship,
in terms of the advertisement.
Lordship,
Therefore, he belonged to unreserved category.
Lordship,
Are we clear?
Lordship.
And
That is
therefore,
so.
his case was required to be considered against that category.
Yes, Lordship,
This is the case. That's good. All of you examine.
Lordship.
Involves a question of law.
Means it is clear, Lordship, that he cannot be means adjusted against the SC categories.
Right.
Yes.
He cannot be adjusted against either of the categories.
Yes, Lordship.
Except unreserved. Except unreserved.
Yes, Lordship. That is the principle, Lordship.
All right.
Yes, Lordship.
So examine it. Yes, examine.
Yes, ma'am. Is squarely covered by that judgment of that Moise Gupta case. Your Lordship is right to that extent. Horizontal reservation means they can be placed as per their position in the category to which they belong. Here, admitted fact, he belongs to scheduled caste. But unreserved category does not belong to any caste. If there is no other, he has been allowed to participate, he can be accommodated in that unreserved category as a PWD candidate. That is the horizontal reservation in respect of
And this, we are giving you an extreme example.
That is right.
Extreme.
Another point. If he has applied in terms of the advertisement as against the scheduled caste, he had an option to be considered for.
We are giving you another example which your commission always does.
Yes.
See, if someone applies for serial caste categories, against serial caste category post, and he does not furnish the details in support of his claim, what do?
Instead of rejecting, to consider him for
General.
You are correct.
Unreserved.
That I have to see, my lord. What is the procedure they are following?
And that is
Lordship
one.
saying
I
this.
also have to see what he has qualified. Is it that with irrespective of marks scored, he will be appointed? It can't be that.
No.
So that you have to see
So
also.
unless you prescribe a minimum cutoff marks, and he has not scored that, then the matter is different.
That is most important aspect.
That is different. Otherwise, even if he is lowest in the merit list, and if he
Then,
qualifies, then you will have to give this benefit of
that. Provided it comes within that.
Within means SC or unreserved, if he was qualifying, he could have been.
Yes.
One
That
would
needs
have been given.
that to be examined.
as jointly requested on behalf of the parties to address the legal issues which have emerged, list this matter on 2 weeks
2 weeks.
to be taken up within first 5 cases.
So all the persons who have been selected have been implemented.
Yes,
Yes,
Lord. They are continuing.
So Lordship ensure the presence because
No,
by using
in
notice.
fact, first of all, address on that question, and in the meanwhile, you can tell all of you that
Yes.
he will have to be adjusted.
Yes, ma'am.
All right, and who will go? Who will have to leave? Only one candidate.
Only one candidate because he is the only one.
All right. So one candidate
Below.
for the
Last-
46th, 14th in the merit list.
My last under the UR category he had to.
Just a minute. Or where is the advertisement?
Advertisement
And-
page 34.
Page 34.
That is
Page 34.
Yes.
37th
30
candidate will go
34.
in the merit list.
the merit list is 55. 55 merit list.
No, unreserved is 41.
Unreserved is 41.
Yes.
Out of them, 40. With merit again.
40, 41, they are women.
14 you can't.
So 41, so not 37, sorry, 27. So the 27th candidate has the problem. You are representing whom? He is representing private respondent. You are representing Mr. Counsel.
Lordship, I'm for the last SC candidate, 47, Lordship.
Last SC.
Last SC,
You
Omen.
don't have to worry.
Omen candidate.
I'm also representing.
OP 47, Lordship.
I'm also representing 27 and I'm also.
So,
Amongst others, I'm also for 14. One of them is 27 as I see in this.
yes,
I'll also take up.
please examine.
Where are his marks?
Pardon?
Where are the petitioner's marks?
Marks, that is confidential. If your lordship says we
Marks
can.
is confidential.
Pardon?
But merit list, if you, how do you draw?
Now it will be crucial.
Ah,
No, that we can present before your lordship.
If the marks is confidential, we will pass a judicial order for making all the marks.
Page 36 of the writ application, I have
No,
no,
the marks. Page
Marks
36
will
to
be
the writ
confidential.
application.
offhand you have
Lordship
said.
knows that Supreme Court judgment. After declaration of the result, that is.
After declaration,
Exactly.
results have been declared in this case.
Page
Ah, yes.
55.
Already
Page
selected and
55 of
recommended.
that writ appeal,
Recommended.
page, that is the merit
Page
list.
56 of the
Founded, they have been
55.
appointed. Perhaps they have been appointed.
That
So,
writ
Baral,
appeal,
which-
page 55.
Page
That is the
56 of the writ
select
application.
list,
Okay.
final select list.
Page 56.
55.
55.
So where is he?
His name does not appear.
My mark is page 56, your lordship.
Okay, okay.
No, this is the final merit list. Final.
Roll number, marks,
that they have
82,
List also should be disclosed.
82617.
Let us see, let us.
Mark.
Doesn't make any sense.
Item number 40.
Okay.
It's item 40. I appear for the petitioner. Mills. Your lordships had on the last occasion heard the matter. If your lordships Mills, have my written note of submission that I have given, I will quickly recapitulate the matter for your lordships. Your lordships have my written note of submission. This is a matter pertaining to the NEET 2022 examination. This is the case of a meritorious student, Mills, who missed out on a government college seat because he was prevented from participating in the third and fourth counseling rounds of the All India quota seats.
So nothing can be done according to you also now, so far admission is concerned.
Yes, ma'am.
You want compensation.
I had on the last occasion, Malaj pressed for compensation, and I had also placed the judgment of the Honorable Supreme Court, S. Krishna Shraddha's judgment, which says that Malaj's compensation can be granted, and your lordship had agreed to my
compensation can be granted, but I don't know how to determine the amount of compensation.
Malaj, I will tell your lordships, Malaj, how it is to be done. If your lordships, Malaj, have my written note of submission at page 3, paragraph 10. I had Malaj calculated it as to how this is to be determined. The current fees, Malaj, where I have been admitted is a college, it's a private college. It's high-tech medical college. The fees there is 6.5 lakh of fees.
How do you?
Malaj, I have put that in my writ petition, Malaj. If your lordships may have page 126.
Is that original copy?
Yes, yes. This is the fee structure, and this has been downloaded from the website of OJEE.
Please understand the difference between
yes
a writ proceeding and a suit. If you are relying on a document for the court to determine the amount, then you will have to read evidence accordingly. You may have to oral evidence may be required, cross-examination may be required, that you are not correct, you are correct. So these things cannot be gone into in a writ proceeding. We can permit you to claim damages by filing any suit or whatever, but this court exercising writ jurisdiction will not determine the amount unless, and the Supreme Court can do that.
Malaj, if your lordships, Malaj, will have one page at page 126, annexure 13 for a moment.
Yes.
Malaj, this is a public document which I have presented before your lordships, Malaj. And if your lordship, Malaj, finds the fees for MBBS course per annum at government institutions.
Sir, we understand.
Yes.
See, in one of the cases which I had decided, I had imposed, I don't remember the amount.
Well, it's 20 lakh
50
of
lakhs.
rupees.
Huh?
20 lakh of rupees, your lordship said.
20 lakh. I had,
Yes,
but I am still not sure whether my determination was correct, whether the approach that he is to be compensated to that extent, yes. But what should have been the basis for computation? Don't know.
well, it's
Then do that.
well, it's
That is my, that is.
your lordships had, while your lordships were judge at the Patna High Court, Malaj had delivered that judgment in Aditri versus Union of India, which your lordships had imposed a cost of 20 lakh of rupees. Malaj, your lordships may just have my rejoinder, the judgment of the Honorable Supreme Court in S. Krishna Shraddha Malaj. Rejoinder page 9, it starts. I will
No,
just.
can you see, if we determine damages in a writ proceeding, we must have some basis to decide.
Malaj.
We cannot do that. We should not do that. And see, I can disclose. I can disclose why I had determined 20 lakhs. All right. And it was there in my mind, and we should not get swayed away by such things. But I got, in that case, that this is the amount possibly which a student is required to pay as capitation fee or something in a private institution.
Malaj.
All right. That is, I am disclosing this from this forum, but that should not have been the approach. That is the. So this is how I am criticizing my own judgment.
I bow down, Malaj. I bow down. Malaj, if your lordships can just have one paragraph, I will leave it at that. And your lordships can, Malaj, then.
Yeah, like we will decide. Yes.
Page 181, running page 181, rejoinder page 23. One paragraph of Krishna Shraddha's judgment, and I will leave it at that.
$181.
Running page 181.
Yes, please.
180, your lordships can have. Your lordships have it, madam?
कौन करता है ये सब? Which paginations? ये सब marking here.
Can be expanded.
Huh?
Earlier they were doing, now they are dropped.
Earlier they were doing.
No, those
I think
pages
it
we
is-
could get there. No, no.
May
Yes, please see.
No, you can do that, but how can we? Acha, this thing can be expanded.
Not visible.
Yes.
I've tried. Let's see.
No. Huh?
Decon. No, he's saying. If this thing is narrow, probably the page is there, but you can't read it. I don't think so. Decon, I have noticed today only number of cases. Decon, no problem. You check. We have to pull them up, so before that,
Well,
we have to be
did.
sure. It is very
Yes.
inconvenient.
Well, it's 13.4 your lordships may have. Paragraph 13 is the conclusion of that judgment. 13.4
Third
pertains
last.
to compensation. May I read, Manoj?
Yes.
Grant of compensation could be an additional remedy, but not a substitute for restitutional remedies. Therefore, in an appropriate case, the court may award the compensation to such a meritorious candidate who, for no fault of his or her, has to lose one full academic year and who could not be granted any relief of admission in the same academic year.
Yes.
Well, it's this judgment actually prescribed three things for a High Court's indulgence, Malats. And the three things were, Malats, that the petitioner was a meritorious candidate. Second, he has been wrongly denied a government seat. And third, that he has availed his remedies in time. Malats, in my written note of submission, I will not be elaborating, Malats. I have dealt with all three. I tick all the three boxes. I will therefore, Malats, urge your lordships to grant me compensation. I leave it at that.
I just really I have filed counter denying that there is no fault so far the authority is concerned.
We will deal with that also.
But that is only I have to
We
point.
don't presume.
Malats, your lordships may also take into consideration the current situation with regard to the NEET examination.
No, that we will.
That is different.
I have
It is not as if, Malats, what I'm trying to say, it's not actually error proof.
What in the application that 36,402 person has been participated in the process in the
We'll
and
see.
that's-
Well, is what they have said. Is these many students participated successfully, but what they have not disclosed is how many could not participate. That is the point.
Yes.
and they
All
also got admitted in the at the college.
I'm grateful.
Item 41.
Valid timing, pardon. 7 days time to give reply to the rejoinder filed with the OP number 4, man. Only 7 days.
So he will seek time for filing reply to your reply to the rejoinder to the counter affidavit.
Say there is no.
There must be an end to the pleadings.
Rejoinder.
See, writ
There some
petition
documents are there. I have to take instruction. They say
must
that
be, is this,
only 7 days, man. Next week I will.
we will give you 1 month time, but not for this purpose. Yeah, writ petition is a
7 days time to take instruction, or at least to whether the documents are correct or not.
new materials have been brought on record.
Yes, ma'am. They filed in the counter affidavit some documents.
You are for,
I am for petitioner, ma'am.
you are for the petitioner.
Again,
They have filed a counter affidavit.
again.
You want to file a rejoinder.
Reply to that one.
Because it's a public interest litigation. Yes, right. I am constructing a house on my own plot in a rural area, in a village. I commenced my construction since 2016. An approved plan by the chartered engineer. A layout plan was made in the construction commenced from 2016. Even to the subcontinent, I have supplied a copy of the layout plan drafted and drawn by the chartered engineer. I completed the house
Filed as a-
2016, only roofing of the fifth floor
Fifth floor.
was to be made. Because of some financial crisis, I took loan from the bank. Then after the COVID period was over, I thought I have arranged some fund for the roofing construction, only roofing, everything, only the roofing. All construction was completed prior to 2017. Nobody put any of that. Suddenly, there was a personal grudge between the present servants and his followers. I suit before the competent civil court. For the very same, they are constructing a house without any approved plan. It is their case. In that suit, they filed an interim application or all 39 rule 1 for seeking a majority rejection as well as temporary. It is nothing.
Thereafter, they didn't file any appeal against me. Thereafter, suddenly, they made some representation to the BDO, Sarpanch, and collector. They see that roofing should be stopped. The Sarpanch on 19/2/2003, after the injunction was dismissed, recommends their representation to the BDO and Tahsildar. Yes, sir. You please take into consideration these things and take a decision. The very next day, before the Tahsildar and BDO could take any action, the Sarpanch passed an order of stopwork against the petition without any notice, without calling him anything. He stopped work. He approached this honorable court, challenging the Sarpanch. He has no authority to pass such an order. Number one. Now, this honorable court, run a single judge, disposed of the matter on 20th June 2023, directing their Sarpanch to take a final decision in the matter after giving opportunity of hearing to the present opposite party number 4 and take a final decision. That order was passed, order was communicated. Since 28/6/2023 till this date, whether the Sarpanch has not taken any action. Then finally, I had to approach this honorable court by way of a contempt petition. That's pending. The notice has been served. She doesn't appear. The Sarpanch doesn't appear. I have filed a contempt petition pending in this court. Notice was issued to her. Then again a 4 or 5 person filed this PI. Now the government, opposite part number 2 and 3,
Yes.
they filed a counter affidavit that was served on me also. The government, opposite part number 2 and 3, they filed. In that counter affidavit, I found a circular matters 2020 notification where, in view of the RERA, certain guideline has been given in respect of construction that are comments or going to be comments in the rural area outside the any development authority area. Means they are covering any construction of the village also. But that was the notification of 2020. That has been annexed to the counter filed by the operating party number 2 and 3. My humble contention before your lordship, and I have filed the counter also, that contention. Then RERA, the promoter, term promoter has been explained, defined under section 2JS. I have quoted in my counter also this promoter. Promoter means a person, even the owner of a land also, who constructs a building, a structure, in order to make units of the apartment, means called flats, for sale. My case is not under that notification 2020, which has been relied on by the opposite party number 2 and 3. Stop work order, that is not a new document. They have submitted it. I have annexed only that Sarpanch stop work notice. That is one annex. One annex only my plan drawn up by the certified. That is the two documents I have.
We are granting you adjournment. Then we are granting you adjournment as you have sought, but with a caution that we are prima facie satisfied. This is malicious litigation. So we may impose exemplary cost. Because if some deviation is there, if some violation is law is there are authorities they can take care of, and he shall fight against that. But why this PIL? And that too in the background of all things, that suit was filed and this, and then you came here. If this is correct, then beware. Because as requested on behalf of the petitioner, list this matter on 1 week. Stop. We are prima facie of the view that filing of the present petition in the nature of public interest litigation in the facts and circumstances appears to be an abuse of the process of the court. Stop. We make it clear that that if not satisfied with the bona fide of the petitioner in filing this public interest litigation, the court shall consider imposing exemplary cost. Yes.
42.
Twenty-seven, 2022, the Pottomedy municipality invited a e-procurement notice, not PIL, it is a tender matter.
Tender PIL.
No PIL, it's a tender matter I have challenged, but rejection in technical bid, what they said.
Tender of 2022.
Let me, 2000,
Tender of 2022.
I am coming. Let me complete my thought. With a tender matter, my technical bid has been rejected. Therefore, I have challenged this technical bid, my lord.
Was there any interim order?
Interim order has been passed in a connected case, my lord.
Yes, where is that case?
That is WPC number.
2431 is connected.
That is there, that is listed today.
Yes, my lord.
The tender matter,
That is
taken to single bench, taken interim order, now continuing.
My lord, I am in the tender matter, but rejection of my technical.
No, but if it's a tender matter, you find.
No, that is not tender matter. That is the cancellation of agreement previously.
No.
From 29/8/2018, my lord, I was the lowest bidder. I was given the
The
work,
agreement was cancelled, so the fresh tender, what has happened?
fresh tender that I have challenged, my dear.
Just asking, wait, you have challenged, you have understood, obviously, you have challenged, the
Sorry, ma'am,
petition is
sorry.
before us, but what has happened there?
But I have been entered L1, madam. Inspector L1 being in interim order and single bench, now continuing for till.
Single bench has stayed the tender.
One notice was challenged. After tender period is over, notice was challenged, that thereafter interim order is continued.
All right.
All right.
So both matters are listed today.
Yes.
Yes.
My lord, your lordship kindly say that e-procurement notice was issued on 27/2022 under Annexure 2, my lord, inviting tenders for doing the sanitization work.
So your date chart has 3 dates, okay.
That is with my lord, the writ application, my lord.
All right.
My lord, here in the sanitation work, they have given the eligibility criteria of the general instruction to tenders, eligibility at page 20, my lord. Let me place that eligibility criteria, my lord. Eligibility criteria, technical bid shall be accompanied with attested photocopy of the following.
Where is the order of rejection?
Rejection is under annexure, my lord, annexure 5 at page 30, my lord.
Where is that? What is there?
They say, my lord, you are informed that this is dated 7/11/2022. You are informed that your bid for the above tender has been rejected during technical evaluation by a duly constituted committee for the reason reject as decided by tender committee, my lord.
Yeah.
This rejection, that what has been stated in the rejection, that is not correct, my lord. I'm taking to your lordships to page, the tender committee meeting, my lord, page 3, annexure 3 at page 25, my lord. Your lordship, I will come to page 25, my lord.
Yeah.
My lord, my serial number is 3 for consideration. I have submitted all the documents to the bottom, serial number 3. Farm registration certificate submitted, my lord, as per the eligibility criteria, my lord. I have shown your lordship in the tender notice. PAN card, the GST clearance certificate, up to the EPF registration certificate, valid labor's license submitted, undertaking for an extra vehicle submitted.
Chandan Security.
Chandan Security, I am Chandan Security.
So please come again to the rejection.
Your lordship, I am taking to your lordship, page 28. Kindly.
Please come to
Yes,
rejection.
rejection, my lord. Yes. You are informed at page 25, annexure 5.
Annexure 5.
You are informed that your bid for the above tender has been rejected during technical evaluation by the duly constituted committee for the reason reject as decided by tender committee, my lord.
Yeah.
My lord, your lordship, there I am tender, what tender committee has decided, I am taking to your lordship to page 28. This is the annexure 3, page 28. My lord, I have shown that I have submitted all the documents, my lord. My lord, note page 28, just after this table, my lord. After technical evaluation of bids, the following 3 firms are valid for opening their financial bid. Then I haven't selected in the tender technical bid. My technical bid has not been rejected, my lord.
Technically, it has not been rejected. You are Chandan.
I am Chandan, my your lordship, kindly. Chandan Security serial number 1. I became eligible for opening up my financial bid, my lord.
Counsel, why are you making the submission? These are three Chandan Security Service, Universal Security Service, so and so. And then as per decision of the tender committee, MS so and so who is now performing so and so
Yes.
has not been depositing GPF contribution.
Yes.
EPF.
EPF contribution
So put up for order.
for orders, my lord.
Yes.
Then, my lord, what they said, the chairman said in the note, my lord, last note as A may be seen as per the notes above and
Complaint.
complaints received and the irregularities of EPF deposits observed, the bidder may not be considered for financial bid. It may be submitted for your perusal and further decision, my lord. My lord, that what they have observed, my lord, financial bid they did not reject on the tender committee did not reject. I became eligible for opening up the financial bid. Only one ground that chairman ordered that his financial.
And is there any criminal case was instituted against you or not for not depositing?
No,
regularly?
my lord, that is not correct, my lord. I have deposited
you.
up to date EPF fund. I have. No, nothing, my lord. No, my lord, I have deposited up to, my lord, September 2022 EPF deposit. You lost it, kindly come to annexure 8, my lord. That region which has been assigned, that is not correct at all, completely false, my lord. You lost it, kindly see annexure 8 at page 34. Payment confirmation receipt, my lord. Total that with month September 2022, I have deposited entire EPF amount of the employees till My September 22 on the date of reopening of the technical bid, my lord. I'm giving all the documents from page 34 to page 56, my lord. Technical bid was opened on, my lord, they say on 28/10/2022. I have deposited this amount on 23/10/2022. Prior to that date, my lord. And I have deposited up to date, my lord. At the filing of writ petition, I paid up to August 2023. All the EPF deposit I have made, my lord. That's the ground on which they have rejected my humble submission with your lordships.
It is not, they are not alleging that you did not deposit the amount.
Irregular.
They say that you were irregular.
I am not irregular, my lord. Let them show what is the irregular.
They will not show, you show.
Up to date,
You
my.
know that you have been regularly depositing the EPF amount.
Yes, I
Make a statement.
yes, I will show, my lord.
All right.
My lord, may I prevent?
Technical bid was rejected on the, it is evident from the report that the petitioner's technical bid was rejected on the ground that the petitioner has not been depositing EPF contribution of the laborer properly despite several reminders in this regard. While performing the work of sanitation work in Itamundal
Pattamadi.
municipality. Huh?
Pattamundai.
Itamundal municipality as a service provider. So, then counsel for the petitioner forgets that the petitioner has been regularly depositing the EPF contribution properly and the findings reported by the technical evaluation committee to this effect is incorrect. So, get an affidavit be filed specifically stating that the petitioner has been regularly depositing the EPF contributions of the laborers properly, and there was no reminder sent in this regard by the concerned authority.
Yes.
So, for the said purpose, this is matter on. When
My lord, you will also grant me 15 days time. I will obtain that all the documents from a EPF commissioner, my lord.
we
2 weeks, my lord.
he is also.
My lord, may I prevent? My lord, I am appealing for the municipality. This case is the second round writ petition, which has been suppressed by the petitioner. Has the petitioner technical filing challenging this tender proceed, the second writ petition, and obtain interim order from the single bench, and he has not mentioned and not given certificate in the present writ application.
What was the necessity for him to file the second writ?
My lord,
First petition he filed to obtain an interim order.
my lord,
And for what purpose did he file the second writ?
my lord, after obtaining interim order from this honorable court, now again he come to this court.
What is the advantage he is going to have?
That writ petition, as the matter relating to tender matter, assignment should be division bench matter. They have obtained interim from single bench matter, suppressing the fact. When that matter I filed appear and counter filed,
First case was filed which was taken up by the single judge.
my lord, interim order has been granted. That tag case.
Oh, in that he has challenged order dated 19/7/2020.
It is not mentioned in the
Governing order in the, he has filed a subsequent writ petition challenging some previous order.
Same self, tender
No,
process.
my-
That is not.
First, my lord,
It is not
only my lord, one
not
minute, my lord.
Not for the writ petition.
My lord, first writ petition I have challenged cancellation of my previous
No,
agreement, my lord.
No, my lord, your lordship.
Previous agreement, my
No.
lord. In previous writ
Your
petition,
lordship have
my agreement was
glanced to that
cancelled.
annexure.
My lord filed the writ petition before Honorable Single Judge that has been stayed, my lord.
No, my-
Thereafter, my lord, when my technical bid was cancelled in the fresh
No,
tender.
but the prayer in the first writ petition, those are previous events. The subsequent event you have challenged in the
My-
second writ petition.
Second,
lord,
not my first writ petition.
The prayer.
That,
Prayer,
I'm
my lord.
looking at the prayer in 24316 of 2022.
my lord, your lordship.
There you have challenged the letter dated 19/7/2023.
Yes, my lord. That's a
Yes.
cancellation.
And in WPC number 31241, you have challenged order dated 28/10/2022 and 7/11/2022.
My lord.
7/11,
My-
my lord, that has been your
My
lordship
lord-
are directed to consider my
Yes,
technical
representation.
representation, my lord, that I have
So
given.
while representation was considered, you.
My lord, then my lord,
the
representation
procedure.
was not considered. They opened the financial
Lord,
bid,
the
my lord.
tender was allowed for
Without
specific
considering
period.
my financial.
After putting up new tender, the petitioner participated. When he became unsuccessful, then he filed this writ petition, challenging that letter. When
that
he
is the
became
cancelled previous
unsuccessful,
agreement, my lord.
after receiving that letter, he participated.
That is not tender. I have not challenged the tender there, my lord.
Yes, lordship.
And you have filed a counter with the.
Already I filed, my lord.
What have you stated in your counter? That we received complaints?
Yes, my lord. Your
Yes.
lordship, don't do annexure.
Yes, I have,
Remained silent.
I have read your counter. We have received complaints.
19 complaint has been received.
So have
several.
you inquired into the complaints?
Yes, my lord.
What have you stated in your counter?
I have received and inquiry has been conducted by the municipality. The fact is true. He has not deeper
Where
details.
have you stated? In your counter.
Already 29.
In your counter affidavit, where have you stated that?
Has been. My lord, in para 7, page 3, that
Yes.
in reply to para 3 of the written, it is settled that the claim of the petitioner that not a single complaint has been made against the petitioner is not correct. The municipality has received 9 complaint from 19 persons who are
Yes.
with
Yes.
the petitioner.
Yes.
If
You
have
have
not,
received complaints. Then what happened to the complaints?
well, an inquiry has been conducted by the
Where have
municipality.
you stated?
But it- My lord, I have annexed all the applications. They have
I have read.
addressed to the
I have
chair.
read.
All the 19 application I have filed
Yes.
before this honorable court,
Yes.
which is written by that the worker,
Yes,
which
yes,
is
yes,
working.
yes.
Since the last,
Yes.
To-
Where is the averment regarding irregular payment of EPF? You are the municipality.
my lord,
Where is your averment?
What was this order dated 19/7/2023, which you had challenged in the other.
My lord, that is the cancellation of my previous agreement. That cancellation of my agreement, my lord.
Initially,
Page
tender
18,
is for
page
1 year,
18.
madam. Tender is for 1 year. After tender period is over. On the second connected petition, my lord specifically court has asked whether tender was finalized or not. Specifically, question was put in the connected petition. In connected petition of municipality has filed a counter.
May I mention a matter? Item 49 in today's list, Manoj. Despite not having the essential prerequisite criteria, opposite party number 1 has selected the bid of opposite party number 2. That is what I have challenged before your lordship. Notice was issued. This was communicated to the other side. And in the meanwhile, a work order has been issued. I have filed and if your lordships can be pleased to list that matter tomorrow. Grateful.
Pardon, my lord. Item 43, my lord. Kindly take on 2 weeks after. On behalf of Mr. Das, my lord, personal difficulty, kindly take on 2 weeks after, my lord.
Did you build that also? Tomorrow.
43, my lord.
Yes, we'll